So this guy here is actually the new chairman of the Petitions Committee.
Good news. The Petitions website is up and running.
So he's a very much a clerk of Parliament type character. But anyway, the Petitions Committee does not seem to have turned a new leaf, and the only thing that I can see in the rules that have changed is that they've hidden and removed the part that clearly said that you can appeal a rejected petition. And now I can't find it anywhere, and I've got to try and search my phone or my hard drives to find proof that it existed. Because it was in the actual policy when they never ever let anyone appeal the decision at all. They weren't even entertaining appealing it. Just making it 5 more signatures, which was a real pain, and then reword it when, if it wasn't against the rules, you didn't need to reword it. And that's really what I want to talk about, these rules for the petitions. Now, there are some actually really serious issues here, some real contradictions in law, which just cannot be correct. And the thing is, how do you challenge the Petition Committee? Because MPs and the committee itself most definitely operate within privileges of Parliament. But the ironic thing is that we're meant to run petitions and conduct the petitions through privileges of Parliament and the Privileges Committee. But we're not getting privileges of Parliament, and the Attorney General is meant to actually be part of the Privileges Office as well, understanding orders as well. There's a Privileges Committee, the Petitions Committee, and there's the Attorney General as well. And then the Speaker of Parliament can issue certificates. For conducting the petition is sharing it, for sure, sharing it online, which is advertising it, and in person as well. It depends what type of petition it is and what you need to do. And once it's published, it's been put up on the notice board and issued by Parliament, authorised for people to pursue the cause, collect the signatures for it. And it's been issued for persons to act to pursue that cause. And what even an affidavit is or a complaint, we can go into that because we're learning all about the form of them now, from all the way through the law, how it's all evolved and changed, and what is it we're actually looking at. But I just want to go through these rules with you, right? Because I'm going to have to send this complaint in, and I'm not well at the moment, right? And this is the thing, I can't be asked by arguing with them, and that's why I've never not sent complaints in. Don't get me wrong. I've never just given up complaining. But at one point, I just give up reading the replies because they just they're no matter what logic you use and no matter how correct you are, they're just stubborn. So that doesn't mean to say that I give up sending complaints in and I don't say you're wrong about this, you're wrong about that, whatever. And to be honest, certain areas of the more serious and bigger it usually is, are the things that I normally get success on by miracle of God, like Stonehenge Tunnel or other things like that. But when it comes to little less important things, but they actually are important, but little niggly things like on websites or little rules and certain things, it's a pain. Although Cat Smith ended up, Cat Smith's not on the committee chair anymore, so but their rules aren't right. And this is the thing. One thing that I want to say about their rules is, one of the rules is that a petition can't interfere with an injunction, right? Now, this is the ironic thing. If a petition can't interfere with or has no authority overriding or over injunctions, or if injunctions can't encroach on petitions, right? Well, that means that this is the thing. What happens, right, if they're saying that you can intersect any petition or any petition cause where there's any injunctions in place or whatever, right, from a lower court when Parliament's meant to be over the top, right? Well, how about this then, right? What about the fact that, here we go here, it's all this here. let me just see what it actually says for this injunction thing. You can't have saying you can't have a case where it refers to legal proceedings. Well, I'm reading the petition archives now, and it's rare when I get a petition out of the archives that doesn't refer to legal proceedings or isn't itself deeply intertwined in legal proceedings, or referring to one, responding to one, appealing to one, involved in other proceedings, mentioning civil proceedings, criminal proceedings, or your answering proceedings, or you're bringing it. The petition is bringing proceedings. There's absolutely no way that petitions committee could ever argue in front of a jury or a court that the actual petition is legal proceedings itself. It is the needs of a case in the highest jurisdiction you can get. Now, if they're saying it can, why? Riddle me this, right? Riddle me this. You're in a court. You've got the criminal procedure rules out in front of you, 2020, right? What are the overriding objectives? You must take into account the needs of other cases. Oh, so needs of other cases might be raised in your proceedings. That's interesting. And you've got to take them into account. You must take into account the needs of other cases. Why? Oh, someone might have a civil case against their wife and it might be on a certain date, or the evidence might be being used in their divorce case, that she cheated on her husband while he was headbutting her or something, and someone's been prosecuted with it. That's something, this is the thing with legally privileged items and information. Parliament's meant to be the higher authority in jurisdiction, and actually they can actually vote in committees in Parliament whether or not they mention it or not. But if you look through history, this actually doesn't stand. It's just some fairy policy. It's like YouTube policy. YouTube policy isn't law, and it's an absolute miracle that they're managing to get away with it when it's beyond the law. They created their own law up that didn't even exist, and they're getting us to obey it and comply with it and act as if it's like proper serious law. When we're doing certain things, when we've got an authority to do it, or it is required or absolutely necessary to do, and it's even protected to a certain extent to channel it through like freedom of press, so that you can it functions, or else it doesn't function. This is the thing. So if it refers to a case where there are active legal proceedings, well, how can you be in a criminal or civil case, right? How would you, in order to assess the needs of other cases or mention that there's an other case with needs, don't you have to say that? Excuse me, can I raise overriding objective HIV, the needs of other cases? Oh, and why might that be? Well, because of case, here we go, abracadabra, case 675734, the needs of that case. Oh, I mentioned it. Oh, what a shame. What a shame. I had to refer to that case. Critical fault and error in law. Whoever in this is not competent, let alone to be a Crown prosecutor or a civil lawyer. This is the Parliament of England. It's like the actual Parliament of England, and they're writing these policies up. But this policy is not legislation. It's not law, and it isn't a resolution of Parliament either. This is not a resolution of Parliament either, right? And it actually it undermines the standing orders of the committee itself, which we'll get onto in a minute. It undermines the standing orders which have to be facilitated for, so you can do certain things. Some of these rules serve to obstruct and undermine the standing orders, right? Now, how can you be in the High Court is what you can have a criminal case in the High Court, right? You're in the High Court. It could be a civil case, but you can have a criminal case in the High Court because you can have a court of appeal and appeal. So you're in the High Court, and the needs of other cases. Well, you've extinguished rebellion in the High Court, breaking a window. That's the thing. Oh, they need to other cases. Well, the thing is, the needs of other cases are parliamentary privilege if it's Parliament and a petition, which actually prevents them from getting put in prison. Now, you can't say you can't raise that matter up and mention it because it's the one thing that prevents you from getting prosecuted, right? But the needs of other cases, they're saying that they can't mention the cause. Well, it's true that the court cannot really discuss or debate the cause because it's for Parliament to discuss and debate the cause, which is really why the courts don't want them to raise it, because raising the cause proves that they've got a cause and they shouldn't be in the court, right? But it's what is overriding objective HIV? According to this, overriding objective HIV can't exist. It's not possible to exist. But so why is this saying that it cannot? It's if you put overriding objective HIV next to this, they couldn't exist next to each other. It can't possibly exist next to each other. It's just stupid. It's absolutely, completely and totally, utterly wrong. Right? And now, where's the injunction one's above that? It contains material that may, doesn't say that will, doesn't say that can, doesn't say is or is not. It just says may be prosecuted by an injunction, or no, protected, sorry, don't know why I said prosecuted, protected by an injunction or court order. So, it's just saying material, but this isn't actually your actions when you're walking around. What about when you're collecting signatures? If there's an injunction or a court order, are you going to get arrested or put in prison? You're not meant to be arrestable. You're not meant to be arrestable or in prison able when you're walking around doing this, sharing it, even if it breaches an injunction of the courts. But if it contains material that may be protected by an injunction or court order, what about the public inquiry or something like that? Supposedly, if they've got... You see, you can have these orders where you're not allowed to talk about things or share or spread information. But Julian Assange is a good example of that. What happens if the court had put a certain press ban on Julian Assange? And what happens if there were certain things going on and the press said they're not allowed to publish it or talk about it, right? But what if someone, maybe a lawyer or even one of his friends or family, knew that there was something really bad going on in prison, or something was going to happen with him being extradited, but we know that political prisoners aren't even supposed to be extraditable, so why would he be in prison? They're saying that you won't be able to petition Parliament about that or mention it. Tosh, absolute complete tosh. You've got freedom of subject. You've got complete and total absolute freedom of subject. It's the new constitution. You see, this is what they're doing with Tommy Robinson now at the moment. With Tommy Robinson, they're saying that there was an injunction on him and he wasn't allowed to play that film in public, right? But the thing is, that film in public is it's an advertisement, right? And the thing with the advertisement is that he's trying to spread awareness of a cause. Now, under the Copyright Act, you can show and share in public, and it doesn't have to actually be a petition. It only has to be a political matter. And you can share it without any rights of other persons interfering. Now, the only way that a person can get an injunction to stop it is usually with they've got the rights to it to stop it. But with the harassment, they could say that it's causing them personal, defamation or harassment. Now, the thing is, if it is a petition, and under that Parliamentary Papers Act 1640, if you get a certificate from the Speaker, it protects you from any civil action like defamation suits and so forth. But you're protected from harassment anyway. You can't be arrested for harassment or put in prison for harassment, criminal matters. So if you did any harassment on the victim, or if it was, if playing the film caused any criminal issue, you can't be arrested for that. But the civil issue, it's not arrestable, though. The civil issue is the defamatory part of it, which you do need a speaker certificate to support that, unless you've actually got a petition. The petition itself is really kind of supposed to be the warrant, really, but the thing with that is that only prevents defamation civil suit for monies, right? And they're claiming monies. But if they've got an injunction in to stop you doing it, you can't get an injunction. Look, right, for the right to display it in public, to make copies or to show to multiple persons, right? If it's political, it says that you can't bring a civil action for that. So if it's not civil action able, it's not injunction able. It just isn't injunction able for the right to show it and the right to make copies. Now, I might not like that myself, you know. Other people might not like that fact, but it on serious matters of state, really, it's not civil claim able in the first place for the showing of it and copying of it. So it cannot be injunctionable. It can't be injunctionable. It can be suable for defamation if it's only just political, but if it is actually a petition, then it's not even defamable. It's not able to you're not able to sue monies for defamatory because it's parliamentary privileges, and therefore you can't get an injunction for that matter either. So it's definitely not civil claim able or civil injunction able if it's political material, just kind of like Assange. Assange actually didn't have to have a petition. All it had to be was political views. And that's important. But when it actually is a petition as well, you're definitely falling under parliamentary privileges, in addition to some... They've got quite a lot of the political views thing covered in the law without you having to actually be doing a petition, just through subject matter, because it's a certain categorization and a certain classification, because it's like, you know, sport or crafts or politics. If it's politics, then it's in a certain band that it's not an offence, and you just can't. It's not civil suitable. It's not civil suitable. So how can you get an injunction through civil proceedings if it's not civil suitable? That's the thing. And all of these are not meant to be criminal charge able, or at least not prison or arrest able on the criminal side of it, you know. So that Tommy Robinson, you know, whether we like it or not, it's kind of, he shouldn't have had that injunction at that point. And it's the injunction that's encroaching in on the other law and so forth. But there is an etiquette in Parliament that they can choose not to intervene in legal proceedings or mention or talk about them. And I think in America I've seen Rand Paul doing that with Fauci and some other Attorney General and various other persons. But it says contains material that may be protected by an injunction or court order. Well, this is the thing. You're actually going higher. I know that there are some statutes that say that, you know, appeals should be through the courts but not by Parliament. But it depends. If it's a matter of great public concern, and if petitioning Parliament is bringing a case to the House of Commons, then really whatever you're doing when you submit the petition and you draft it and write it and send it in, or whatever is contained in it, really that cause should and would be subject to a similar or near identical principle of the criminal procedure or civil procedure rules, or a blend of both of them, but at Parliament's level, which could be taken into account the needs of other cases. Well, you might say, well, the needs of this case are the injunction, right? Now, maybe that's what they're doing with Tommy Robinson. Maybe they're saying, oh, you know, taking into account the needs of other cases, there's an injunction there and you broke it. But it's definitely, the thing is, you can't, it's not civil, playing a live in public, political, in a public meeting, a political material for a political cause is not civil suitable. So it can't be injunctionable. You can't stop anyone from doing it. That's just fact. Now, if the result of you doing it when they can't stop you because it's not civil suitable, then through your freedom to make copies and show it, if that results in harm, right, defamation or whatever, then they can claim damages against you in civil suit, unless it's further than just political subject, and you actually are you are collecting signatures as a political cause, and then you fall under privileges, and if they don't acknowledge the petition exists, then you get a certificate from the speaker, and then it's not defameable. Then it's not only civil suitable for copying and showing and displaying and distributing, it's actually not defameable either, which is, it's separate, but it's another act that comes into play, because each of these acts actually, when you look at them, they cover all the different aspects of it. It's not actually it's not able to defame in law, or you're not liable for it, because it brings it into Parliament privileges. Now, Parliament might not want to do that because, you know, they're wanting to keep their image, you know, like all above board, and like this, you know, Clark guy that's on this video, you know, all kind of like prim and, you know, kind of like, you know, all like this.
If a petition gets 10,000 signatures,
you see, they're wanting to keep it all, you know, keep the image and so forth. But the thing is, this is the thing with Parliament, right? Parliament, Starmer's putting policy through government. Starmer's saying, right, we're taking your winter fuel allowance away. Right, now you can wear a shirt and tie, and you can have a very clear accent, and you can speak very, you know, plain and affluent, and you can be very presentable, and you can, you know, you can not swear, and you can, you know, open the doors for people, and you can say, this is Parliament, it's the League of Extraordinary Gentlemen, and you can say, the Right Honourable Sir. You can reel all this stuff off, but you've just dropped someone's winter fuel allowance, and they might freeze to death. They might not be able to afford to buy things. You're causing pain and suffering in these people. You might be building a housing estate next to them, which they can't stand, and has ruined their entire life and causing them distress, and they might end up losing their job. You know, these prim people are actually, through their job, they're making decisions in Parliament and voting on things which is actually causing harm. It could be causing more harm than defamation. It could be causing more harm than the defamation that, you know, Tommy Robinson's causing on this, through this, playing this video. But if Keir Starmer drops that winter fuel allowance, then it's like, oh, I've got the right to do it. I've got the authority. It's, I'm very sorry, but I have to make decisions. It's the job. You know, but, you know, I made it, you know, at least, you know, we can't see the mess here in Parliament, you know, keep all the corridors clean, you know, it's dust-free here, but there's people around the country, you know, walking up the road with a plastic little bag, being tortured, or tortured by multiple noises, building sites, airplanes flying over them, cars, having no money, and the kids starving, and whatever Jeremy Corbyn, you know, wants to throw into it as well, you know, with food banks and all the rest of it, or just not being able to turn the heating on. That hurts people. These people they're making decisions in government that harm people, and they're just saying, oh, it's just a neat and tidy job at a desk, you know, it's not like I'm walking into the back room, like, you know, with a fucking abattoir and, you know, slicing a pig up and, you know, sorry, I'll swipe the blood off my shirt, you know. You don't see that, because it's like children. The abattoir is behind closed doors, the abattoir, you know, and then, but the thing with Parliament is, they've got the mess outside, because they've got all these people. They've got, you know, the police are having to keep everyone back. They've got all these banners, you know, like get Starmer out, Starmer's, you know, treason and all this and that. And it is outside Parliament. So them saying, like, oh, we don't want this on the website, we don't want that on the website, it won't make us look respectable, or, it's a silly thing, or whatever, it's almost kind of like saying, don't paint the wall, but there's someone stood next to it, with paint all over them. It's they're not wanting to get dirty, but they are. It's surrounding the building. It's been shouted and chanted. So it's sort of like them saying, "Oh well, we get it off this website." But that website, it's effectively it's like the public notice board. It's like the public notice board in the village. It doesn't really. It's meant to be the taxpayers. It's actually meant to be the taxpayers. Now they got elected and voted in. They get to go into the building. They get to walk into the building and sit in it and touch the staircase and touch the banister on the stairs and go sit on the nice green leather seats or whatever, and go put the petitions in the petition bag, right? They get to go sit on the chairs and they get to speak in there, right? Our right is to collect signatures on those causes, right? It's our public. That's our section there. That little notice board, the little notice board. That's our bit there, like in the village, like I've got a village fair on, or someone stole my cat, or I've lost my jacket, or whatever, or, there's a criminal around here stealing some cars, or whatever, has anyone seen him? That's a criminal matter, or whatever. Now, fair enough, if you just put Johns and Ons, and that's it, well, it's not asking for anything, is it? It's not a prayer, and it's not a complaint, fair enough, okay? If you just put Johns and Ons, then fair enough. But saying that, then you've got this whole matter of the Monster Raving Loony Party, right? Which, let's get to some more of these rules, right? It says that on here, it says that defamatory, libelous, or illegal in a way making false or improving statements. Well, you're trying to prove it to the committee. In a statement and with evidence, you're going through the process of proving something, right? You can't making a false statement is lying, right? And if you're proven to lie, then that's a breach of privilege. But when it says unproven statements, they're not wanting you to be able to try. Right? When you bring a suit or you bring a case, it's called trying a cause, trying a case. You're going to court and you're going to try to prove that someone broke the law, or to prove that someone owed you some money. If they already knew whether they did or did not do it, or whether it was true or false, you wouldn't be going into the court, right? This is a thing. So it's yet to be proved, right? They're claiming that they want it to be proved before that you submit as evidence. But the whole point of submitting as evidence is that you are showeth. You are attempting to prove it, and you're not only just proving it to the people, you're trying to convince the people to support it, and you're also trying to prove it to the Parliament when it gets debated. But they're wanting to kind of be the judge. I know that courts sometimes don't disallow certain things and certain evidence, but you usually get to debate that. You usually get to have a say in the court, introduce the evidence, and give reasons for why you want it. And then if anyone objects to it, then it's an objection. I object. The prosecutor objects, and then you say, well, why do you object? And then you go through the process. What this committee is doing is... You're at a distance, and it's just brick walling you. It's just saying, no, we're not having that, no, we're not having that, no, we're not having that, no, we're not having that. There's no, they're not saying, oh, well, I object on this or that, and then you say, well, and you argue it through. And what that does is it's defeating, and it's not only defeating, it doesn't even give you a chance of debating or arguing. I mean, if they ran a criminal court the way that they were in this petitions committee, no one... I dread to think that what had happened, or a civil case. This is why the standard needs to be raised. There's no. It's literally like, and the small amount of writing and information that you can put on there is insulting to the intelligence in what are the most... These are more serious than a criminal case. It's more serious than a local crime in a magistrate's court. It's more serious than a civil claim in a county court. This is like the most important and highest level serious causes that you can have on the planet. British government and American government, at government level, at federal level, there isn't anything more important. And what these MPs are doing and making decisions that are affecting people's lives. But they say, no, we don't want to put anything rude on there. It might upset someone, but then Starmer can stand at a podium and he can say the words, oh, I'm taking your winter fuel allowance away. And apparently that doesn't hurt anyone. There's no pain. There's no anger. There's no suffering. Well, you can't see it the other side of the camera, but people are in the houses, throwing the microwave across the kitchen, and picking the TV up a Starmer and throwing it out the window, infuriating. Apparently, it doesn't, he's pretending it doesn't exist. And this is the thing with TV. This is why television has managed to keep all the negative stuff out of and off TV, keep all the smiles on television, keep the facade that, everyone's clapping in the audience and everyone likes it. And that's what Parliament really want to do with this Petitions Committee. They want the Petitions Committee website to kind of look like a morning TV programme. Everyone's happy, everything's okay, everything's kind of normal, sensible and prim. When Starmer walks up there with a nice, neat suit that's been ironed and says, well, hello everyone, I'm your Prime Minister here. Now I'm going to lower your winter fuel tax. Ow, 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 my wallet. This is the thing. People are actually painfully responding to some of these things. There is actually suffering and pain, rather than having, a couple of, ruffian swear words in a petition or what, regardless of etiquette, it is pretending that everything's all happy and all right. None of these petitions are happy and all right. Have you actually read the archives? If this petition website actually, if you got all the Dr. Brodie Waddell research archives and you put them in, in writing on this website and publish them now, but change the names to people now, that Petitions Committee would have a heart attack. But that's what it is, I think that they literally would have a heart attack. They won't be able to handle it. I've got a folder open over there, right? Those are all the things that they're sending in, right? Which is traditionally meant to be, right? The Petitions Committee would seriously have a breakdown. None of them would get on there, but yet that's what it's meant to be for, I don't know. There's not one of those where someone isn't got a critically emergency near emergency situation, or in some cell that is not fit to live in, and they fear for their safety and death. Some of those conditions in some of those cells that they've been put in with slime everywhere, and that it is the conditions that Keir Starmer's putting some old age pensioners in. In fact, some of them might think that they've been put into a detention in a cell by the time they're frozen to death. I want to try and get through some more of these. I think I'm going to go through them one by one. Calls for action at a local level. Right, so I've got quite a lot to say about that one. So they're saying that you can't publish a petition on that website if it calls for action at a local level. Well, I'm absolutely certain that, for starters, the Stonehenge Tunnel, that was local level. The Stonehenge Tunnel was submitted to Parliament and they withdrew the project, but there's still a couple of planning orders left over from it. That's a local level petition, and some of that project was council local level. Now, the 1661 Tumultuous Act, all the council cabinet, the committee of the council, or justices of the peace, they're meant to be, right? And In fact, it's even supposed to be the court anyway, let alone, it's meant to be the court anyway, the council, right? Now, you've got 5-10 minutes are allotted in law for every matter that's heard in the council for petitions, right? And in the 1800s, even up at least up to the 1800s, I would have thought up to 1986. I'm thinking now as well. You can have it. You can defer. You can say I don't want it heard by the council. You can say I want it heard by the court with a jury. And how do you do that? Well, it says you petition for it. You put a petition in and say you want it heard in the court instead, or Parliament, right? That's in the framework, but you've still got a petition. You've still got 5-10 minutes for. They've got to hear petitions, but what petitions? Well, whatever you want. There's absolutely nothing in those council rules that say what the petition can and can't be. Nothing. It's impossible for them to stop it from being this or that. And the Local Government Act says that you can petition the Secretary of State for a local referendum. Now, if you're allowed to petition the Secretary of State for a local referendum, then you can do it on the Parliament website. This is the thing. Now, you possibly could do it on the local council website. They've got a petition site, but why does it matter? You're asking for the same thing. And if the Secretary of State is the person who has got to approve it, but Secretary of State is in Parliament, so why would you run it on the local council website when the Secretary of State is in Parliament and he's the one making the decision? Doesn't make sense. It's like either or. But the thing is, if you're in the local council and you say we're petitioning Parliament, then it effectively, it's like being in a magistrate's court and saying, right, I want to appeal it to the Crown Court. And then they how does the magic happen? Well, they ring them up. This is the thing. How do you get a local referendum from the Secretary of State? Well, the head of the council rings them up and tells them, that you want it. Someone talks to someone. This is the thing. They're saying you can't do that. That's a lie. You can do it. They cannot stop you from doing it because you've got the right of the subjects. You've got the right of the subjects. It's in the government of the country. It's a matter of the government of the country. It's hierarchical. Everyone has got the right to a random jury in decisions in law because that's in Magna Carta. Now, I know that the councillors are effectively jurors, but they are the lowest. They're the lowest level. They're the entry level. The councillors are the entry level, and there's a lot of them now, and they're all members of political parties who are all. They're not even impartial. They've meant to have signed a selflessness policy, right? But apparently they call it control of the council. How if they've got some control of the council, then that means they've got control of decisions that are getting made. Have you ever heard a jury saying that they've got control of the courtroom? Have you ever been into a criminal court and then someone say, no, Labour have got control of the jury, or the Conservatives have got control of the jury? Now that sentence definitely means something, doesn't it? If you walk into a courtroom and you say the Labour Party have got control of the jury. Now, if you're a guy who owns a mill or a factory that Luddites were smashing up and wanting to stop you because government wouldn't raise the working class wage up, and then you walk into a court and then you're going to be deciding whether or not McVitie's can extend his factory or whether his wife gets half his money or not, and you say, the Labour have got control of the jury. Now, that's a statement for Keir Starmer, isn't it? But I don't think Keir Starmer didn't do criminal law until he was in charge of the CPS. Apparently, he was a human rights lawyer. So I don't really know why they picked him. Maybe because he didn't really know what he was doing. Those cases in the High Court don't really have juries. Apparently, they're judged on these really long, complicated statements and so forth on human rights law. And not even privileges. That statement, I think, breaks the whole thing. Because if you say the Labour Party have got control of the jury, right, then you can see why they wanted to get rid of the juries, particularly when in the massive industrial boom, when all the factories were getting built, but they were laying people off, and then they were losing the skills. They were losing their, my dad was a toolmaker skills. And then the police force, they made a massive police force to deal with all the crime. And then when they realised that all these things were getting built and done, and because they've lost control of the juries, and Labour didn't have control of the juries anymore, then everyone's just like going, and the women can't vote either, and then like, it's. I think that probably did spur into the suffragettes then, because then you get into 1900, which is the suffragettes, and they're just going, we want our vote now. Well, why were they so pushed for the vote then? Why didn't the women kick off for the vote in 1800? Well, I don't think they took it away from them, didn't they, for a while? But I think they were actually really bothered about not having the vote, because they'd lost control. They'd lost control, really, of what was getting built, I think. And also they've been all herded into the Labour Party, and because they needed to get a grip on them, didn't they? Because Luddites smashing up everything, and then they're complaining about the wages and so forth. They needed to sort of like get them in order, like get a grip on them basically, and get them all working. But then say, oh well, we'll negotiate for better wages or whatever. But they never really did they? I mean, Jeremy Corbyn says that he wants, all the public services to be free and for non-profit, but he's having a hard time doing that. And now we've got this cost of living crisis, prices, inflation, all the rest of it. People aren't any better off. They've got modern things, they've got new stuff, but it's and then they always seem to find a new way to bring crime in, a new way to influx crime in, and then now, as well as just inventing the Met Police, then they're inventing the surveillance state, So you can actually petition of things of a local level, and this rule is wrong, and I challenge him on that. This is the thing. How do you challenge him on it, though? This is the thing. They say apparently the Petitioners Committee have got parliamentary privileges, right? How can I take them to court if they've got parliamentary privilege? If I walk into a county court or into the High Court and say I want to prosecute the Petitions Committee, or I want a civil suit against them, then they won't let me, because they'll say it's parliamentary privilege, and then they'll be stopping me from doing it, right? So how can I make them do it? How can I get them to do it? Well, you could petition them. Yeah, well, they're not letting us run the petition, and then they're not letting us put it up on a notice board so people know about it, so they can sign it, because they don't want them to know about it. They don't want them to know that there's something that needs sorting out or something wrong, And then what about the so how can they say that if an injunction? How can an injunction? And this is a thing, we're meant to be covered by privileges as well for going about, not just Petitioners Committee. We're meant to be about sharing it and going about pursuing the warrant on the cause, right? How is it that an injunction, right? An injunction cannot interfere with Parliament, right? Supposedly. Or they're saying that Parliament can't interfere with the legal process of other court cases. But this is the thing. What happens if I bring a court case against them? If I bring a court case against Parliament Petitions Committee saying they're publishing false rules, right? Well, I can't. So the thing is, well, can I get an injunction against them? Can I get an injunction from the civil court to stop the Petitions Committee publishing these rules, right? No. Why? Because it's privileges of Parliament and their own jurisdiction, right? So how can they get an injunction against, sharing my petition? How can they get an injunction outside Sadiq Khan's house for sharing the petition? How can they get an injunction from Tommy Robinson showing his political video if he was doing a petition? Well, they can't, can they? Because if they could, then I could get an injunction against that committee from putting these rules up because they're wrong and illegal, and I could challenge it in the court. But they won't let me because of privileges. What they want to do is they want to pretend they exist when it suits them, and then they don't want to pretend they exist when it doesn't suit them, when it suits us. And that's the problem with these rules. Next one. It calls for action relating to a particular individual or organisation that the UK government or Parliament are not responsible for. Well, again, if we, as far as I know, since 1688, the law and rules for petitions has not changed. We've got some standing orders. I haven't seen anything in the standing orders that say anything like such as that, and I haven't seen anything in any of the resolutions that say anything like that, or any law, right? So as far as I know, it's ticking over on the 1688 Bill of Rights right to petition, which is freedom of subject. Now, if the Petitions Committee, right, want to acknowledge the National Archives petitions and subjects, right, that exist of the things that it was designed and made for to do that, right, then they could put this entire archive folder that I've got on there up on that website in the modern petition form. If you could fit them on there, because there's not enough words, they don't even let you say enough words to fit some of these on. Some of them will fit on there, but most of them, they don't even allow enough words or writing to fit some of these petitions on. But there's not one of those petitions which doesn't mention someone else's name or have a grievance against another party or person. I don't think there's one of them, hardly, except maybe, when they're giving them permission to trawl up the River Rye or whatever, and they're wanting to, he's stealing all the business away. But then it's still, this can't, if we take into account the study specimens that I've got, right, and it's still running on the same underlying legislation and basis, then these rules can't be possible. But they're only a policy. But a policy, what do you enforce a policy with? Well, law and rules. But Parliament rules, standing orders and resolutions, they're the ones that have legal effect. Resolutions and standing orders. And then you've got the actual proper law, right? But these are just policy rules. What it is because they've got YouTube and Facebook getting everyone to submit, consent, accept, right? The law are the rules of this country. The law of the country is the rules. Now, if that's not good enough, then you haven't got a very good government or country. Now, the thing is, this government it's not enough. They're not satisfied with those rules, with the law of the country. They want more. Even though they're the ones voting on them and putting them through, they want kind of like another layer of rules that go further. And because they think that they're the ones who are making all the rules and setting all the laws, they're actually now in a fantasy state of mind where, we're putting legislation through all day. We'll just make some more rules appear and for this committee, and that shall be the law. No. The law is in the Constitution, or in the standing orders, or in the resolutions, right? The law is not just make-believe when it suits you because it's, politically correct on the website, and you think that, no one won't upset anyone, but Keir Starmer's upsetting. Who isn't Keir Starmer upsetting? Parliament is in the business of upsetting people, if not making them bloody furious, right? They're standing outside the building with signs chanting. It's not a pleasant business. So, who are you fooling? Whose illusion is it that, want to pretend that, there aren't a massive mob chanting outside with signs? This is our notice board for us, right? Which we are allowed to collect the signatures from people to support it. It's our little section. It's our little part. And, the MPs go into the main building and they get to sit on the seats, on the green leather seats, and they get to debate and argue in there, right? And we get to write these complaints out and collect signatures of people who agree with us, and then we get to prove it in the Court of Parliament with evidence, a fair chance of proving it. Not like, they're deeming whether it's true or false before you even... how they're trying to make it out now, this thing, they've got this rule here that's saying, it's already got to be proved correct before you try the evidence. That's like saying to the Crown, it's like that a Crown prosecutor would have already had to go to court and prove a case before he starts a prosecution. It would be like a prosecutor has to go to a court and prove that this is a hammer, and then prove that that's a jacket with blood on it, and then prove that they're fingerprints, and then when the judge has made an order that they're all what they say they are, then he can go to court and he can submit them as evidence, and then he's allowed to display them in the court and prove it. And I think they've got this ideology whereby that anything that the police looks at and checks and so forth is legit, just because they're the police, and therefore it has to be true, with the fingerprints, just because they've been to a police lab, then, it's all checked, yeah, that they're okay now. No. When they're in the court, you've got to prove to a jury that these are the right fingerprints, so it's got a certificate. That's to prove, that's to substantiate it, right? You're proving that when you go into that courtroom, right, we don't have to go into Parliament with a certificate from a lab that says these fingerprints are all unchecked and so forth, right? That's police standard and procedure. The police lab is not a judge, and he has not written an order, right? The laboratory is trying the information. When you get fingerprints in a courtroom, right, by a police scientist, you're still trying to prove they're right. He's not a judge. He hasn't made an order. He's a scientist. He's a professional witness, and he's attempting to convince a court that those fingerprints are legit and came from that person. I can be sat on that jury and I can say, fuck off. I think that certificate is tosh. That guy's called Fauci. He's a complete, utter, compulsive liar, and Rand Paul is going to put him in prison, right? That's the thing. Fauci's a scientist, but he's up in front of Rand Paul that he's been saying this and that and this and that, So, this is the thing. Just because it's Fauci, Biden's like, yes, Fauci, no, Fauci, 3 bags full, Fauci. Fauci could fart and it would be acceptable as evidence, right? This is the thing with Parliament. Unless they want every single thing submitted. Oh, it's Dr. Tess Lowry, you're trying it. And I know the standards, but when you go to court, you don't have to be a professional, right? If you go into that courtroom with some fingerprints that you got yourself, well, you've got a legal right to convince that judge and a jury that, you're competent to take the fingerprints, you did it properly, and these are the fingerprints of the person, and that they were on the vase. And you've got just as much right to do it as a professional laboratory. And just because, this is the thing, you show it to them and they have a look at it. And, you're trying the information. That's the point. Parliament don't want to let absolutely, and really, they're actually, what they're doing is, it's what the truth of this is. It's like what Robert F. Kennedy Jr. said, there's misinformation and malinformation. Well, what's malinformation? Well, malinformation is information that it's inconvenient for us because it might not make us look good, or it might actually prove that we've done something wrong or bad, And this is what the Petitions Committee, they don't want people. Yeah, I mean, what they're doing is they're kind of behaving like YouTube, effectively, and Facebook. They're just saying, we can remove this, we can remove that, if effectively make up an excuse or just, say, it's policy, right? When the purpose of the right, it channels a path through for you to be able to do this. because you are challenging the government, and you've got a right to try and get people to actually support you. And what they're doing is they're actually, because everyone can see it and it's on the government website and on change.org or whatever, they don't want you to be able to try to convince other people, and they don't want you to actually be able to get any support. And they definitely really don't want to help you, because it's almost kind of like this control of the council business, Labour have got control of the council, or Tories have got control of the council. In a way, you're getting some amount of control in Parliament, but that's the point. It's called usage of Parliament, right? You've got the right to use Parliament and attempt to get things put through, and this is the thing. It's the modern technology. So as for we got to individuals or organisations. Well, those petitions are actually absolutely filled with individuals and organisations, because organisations were actually petitioning. It was like the weavers of the Cotswolds or Cirencester, or it was like the it was kind of like the guild. They had like the Carters Guild of Surrey or whatever. That's an organisation relating to a particular organisation that the government or Parliament is not responsible for. Calls for action relating to. Well, this is the thing, that Laura Corrigan, right? Laura Corrigan petitioned about tampon tax on behalf of all the women of England, right? But it could have been the women of a yoga club in Shaftesbury. Now they're saying that it can't relate to a group, but you actually can do that. Relating to a particular individual or organisation that the government is not responsible for. Well, this is completely and totally false. They don't want you to be able to mention certain groups on there because they're getting a bit of publicity and a bit of knowledge. But to be honest, the entire tradition of Parliament is built on it, funnily enough, because before these big corporate entities were doing all the lobbying to Parliament, and people were like Keir Starmer's, dad, the toolmaker, they did get a bit of publicity. It was actually the Guild of Master Craftsmen, or the Guild of Cirencester Weavers, or even the sheriffs of Cardiff or whatever, and they were actually getting. It's written on there. It's written down. It's written in there multiple times in the title and in the main body of the petition, and many of those are published in the sessions of Parliament. You'll find them. It's the guild, right? All the weavers of the Cotswolds, and the weavers of the Cotswolds are getting publicity there. They're a group of people who are card making, the card makers of Gloucester, right? Well, the Sessions Book of Parliament will have, the card makers of Gloucester in there. Now, if that ain't advertising card makers for Gloucester, and they're even saying that they want us to stop importing card from France because it's taking the business away, right? So, Starmer's on a losing battle with these rules because they can't be. There's no legislation put through Parliament that prevents you from doing it. It's nothing in the standing orders. And where's the resolution? Show me the resolution that was passed by Parliament. This is YouTube policy. This is like any reason or no reason we can reject it, which they can't. This is like wishful thinking. We wish we could stop people from doing all these things, but that, are getting them a bit of publicity in the process, or are inconvenient for us, or might even beat our party, or letting people to know things they don't want to know them about, like certain privileges or acts of law. You can't write on a tap that you're not allowed to use water, because that's the point in having a tap to use water. But yet all these big companies are getting on all the money they're making out of us. They're using it massively to get lawyers, lobbying, private meals and dinners, the whole lot, the suitcases on the table, on all the local councils for the planning things that they're not letting us petition Parliament for and get any help to oppose it, or even get a jury of people. It's scandalous, these ridiculous rules. So they can't have that one either, because those petitions disprove that is even possible to omit or exclude. Oh, well, no, we've just made these new policy rules up now. But based on what? You've made the new policy rules up based on what? Oh, based on, we think as MPs that it shouldn't really have the company's business on there, name on there. Or do you? But where does it say that in law? Did you put a standing order through Parliament? Has there been a resolution on that? No. So on what authority? Well, on the authority that, we can. Because, it's our website. Well, we're the ones sat there at the internet. We're the ones who publish it on the website. We're the ones who write the rules. And we're the ones, by the doors of Parliament when everyone's chanting and singing outside complaining, because we can. But it doesn't mean it's lawful or not all right. Well, this is the thing. Well, I'll take you to court then. I'll challenge you. Your rules are illegal. Well, we've got privileges of Parliament. You can't do that. Well, I'll get an injunction against you then. No, you can't do that. Well, why are you getting an injunction against Tommy Robinson then? Why are you getting an injunction? Why do you get an injunction against Laurie Corrigan, with tampon delivery? This is the thing. They can, we can. They can, we can't. Well, we're actually using the same law. We're using the same powers. We are using the same powers as the Petitions Committee. This is it. So the organisation one. So the next, let's trigger the next one down now. It is defamatory or libelous or contains false or unproven statements. Well, this is where they're really getting wacky far out on the YouTube policy, and on the TuneCore policy. These really whack lawyers who just are making pure false statements which cannot be true, any reason or no reason, what even an illegal reason, Well, nothing is proven or unproven. You're trying to prove it. That's why it says, I hereby showeth. You're offering evidence. You're trying to prove it, right? And at that stage, when you write the petition, you've got a legal right to get people to sign it before you send it into Parliament. Now, that's the signature collecting stage. Everyone has a legal right to see the complaint. Whoever you get to sign the petition has a lawful right to see the complaint, right? What you write, you showeth. And in fact, you are all giving evidence and statement on it, really. Now, what Parliament are trying to do is they're attempting to take these 5 signatures from you, or 20 signatures, and then they're going to decide whether or not you're allowed to get any more signatures, but it's the signatures that are also evidence. People have got concern, or we all believe this is true, right? Now, the thing is, if the police laboratory get some fingerprints and a certificate to say these are legitimate fingerprints, you haven't proved that they are the fingerprints, but the police act like that it's all done and finished. They've proved it. No, if the court don't think that they're legit, that's it. It's almost like the speed cameras. The police chief is filming everyone, sends it, pay the fine, submit consent, accept, admit you're guilty, go and admit it, pay the fine. He's holding pleas, right? But it's like, it's the video cannot be disproved. It's like it's a fact. No, the video is nothing. The video is nothing until you go into that court. Now, it's enough for the police to arrest someone, or even send them a letter, or even come to, maybe ask the court for a warrant. Even then, you haven't proved that you did the offence. But the way they've got such a monopoly on now. Every single thing they do is, according to them, like the fucking sun shines out of their ass. It's the truth, right? And everything you've done is a lie. This is the thing. Nothing is anything until you get in a court in front of a jury. This is the thing. Well, he's a professional, he's a professional, is a professional. Nothing. He's a Fauci. This is what he is, a Fauci. And there's a professional scientist sending stuff into the government left, right and centre through COVID. You've got Tess Lowry, you've got Dr. Campbell, you've got all these professionals, right? And the government were just ignoring them, blanking them. You know, all our professionals. Well, I'll see you in court. Who's the professional? And this is what they're saying here. Oh, we don't accept unproven things. You go to court to prove it. You submit it to Parliament to prove it. This is the thing. You don't. You used to have to go to a court in the Tumultuous Petitioning Act if there was over 20 people, right? And you had to get approved by a jury. There's no such requirement. No petition has to get approval by a justice or a jury for you to petition Parliament with it, right? Nothing. You don't have to get any jury or judge, and you didn't have to get it if it was under 20 signatures, and that was nothing to do with the evidence or writ of the petition. It was how many people you signed it. You know, and on this defamatory thing, the defamatory aspect of it has already been dealt with thoroughly. The entire sessions of Parliament in 1837 were focused primarily about Parliament causing defamation by the material that it published, and the fact that it was, shall it give itself immunity from it? Well, if it thought it might upset people, then it wouldn't have. They decided that they're going to give themselves immunity from it, and for any document, even a petition, anything that is for the purposes of or published by Parliament, right? So it's not defamable in law. You can't. It's not civil suitable for defamation. So in law, it can't cause defamation in law, right? Now, if the guy in Parliament, in the nice gentleman with the spectacles, right, wants to say, well, I don't really want to defame people. Well, this is the thing. It was decided that, Hans had got sued for defamation against a person, and they said, well, should we not do that anymore? We'll stop defaming people. No, we'll protect ourselves, so then we can't be liable to defamation, particularly if you've got half the petitions in the archives accusing people, of abusing privileges, lords protecting themselves with privileges and stopping their servants getting prosecuted, or Lord Stafford with his travelling circus, Lord Stafford's travelling circus with his entertainers, some kind of Virgin Branson band of troubadours or something, travelling round and picking people's pockets, and then they're all protected by privilege. Oh, it's, well, you owe me £50. Well, it's tough. He's one of my servants. There's some defamation going on there. Don't want them to know about the barons and lords' servants getting out of, paying people their money back they owe them, when they've been freeloading loads of, barge rides down the river for, 6 weeks, and they owe him like, 500 quid, and oh no, I can't pay you that back, well, I'll take him to court with an injunction. Oh, he's protected by privilege. No, you can't get an injunction against him, this is the thing. That was all decided in the 1830s. That they're going to cover themselves for defamation, so they're not bothered about it. It was decided that is not only resolution or standing order. That was actually It wasn't just resolution or standing order. They made an act for that. They've got a full act of law for that. You get a speaker certificate. I don't think that you need one because the fact that it's on there, it's on that website, and that it's live. Although the speaker certificate has some kind of judicial authority, to exercise it if they're not. But they should know that it's parliamentary privileges. I don't necessarily agree with it. That's the thing. Maybe I don't know about this whole Tommy Robinson business with that film being played in public. I'm not saying that I agree with it or not, but what I'm saying is you have to tell this is what the law is at the moment, whether we like it or not, and there's no point just making things up to be politically correct. They did it for a reason. There was a reason why they did it. So what have we got to now? There's one here, nonsense. Oh, I ain't got that far down yet. Contains material that could be confidential or commercially sensitive. Well, now they're getting into the whole COVID issue, and chocolate bars being harmful for people. That it might, if you say, "Oh, we need to ban Coca-Cola because it's making people ill," but people need to know that, don't they? People need to know it, and they need to stop it. You're actually preventing people from acting. Now, if you've got strong evidence that showeth that harm is happening from a product, it would be actually irresponsible and possibly even dangerous for the government to obstruct or block you from putting that in a petition and publishing it, even if it was harmful to Coca-Cola. And again, that's defamation of a company. You're protected for that. And I actually think that, this is all their lobbyists and the whole deep-rooted Boris Johnson, Matt Hancock, Tory side are trying to protect the interests of their Rishi Sunak companies and investors and so forth, BlackRock, Vanguard. They definitely can't stop you from doing that because it could be actually dangerous or serious. And if there's an opposing party in Parliament trying to stop you from doing it because they've got investments, like Nancy Pelosi, for example, if Nancy Pelosi got investment shares in those companies and we needed to ban it and make it illegal, but you had to mention them, you've got a legal right to do that, and no one should try to stop you. It's like trying to say, can you imagine? It's like saying you can't actually have a civil case against Coca-Cola because it might harm the reputation by the fact that you've named the company, you've named the respondent. It's just so ridiculously ridiculous. They're really coming up with the fantasy policy. It's just like a fantasy policy that can't possibly. It writes off petitioning, so you can hardly do anything. And those laws were meant to channel straight through it, so you could get it done. Contains material that may be protected. All right, we've done that injunction thing, legal proceedings. So we've got commercially sensitive. See, that's exactly what Robert F. Kennedy Jr. is wanting to do now. Try to do something about all these companies. And he's actually been saying, that things like eczema and all these other diseases were very minority. And now that there's loads of cases of them all around, it could cause. I'm going to move on to the next one now. So you can't really have that one. If you can't have that, you can't bring a case at the highest level in government about something that could be seriously dangerous or hazardous, just because you worried it might affect some company or business. It could cause personal distress or loss. This includes, but they were petitioning about loss. Half of these petitions I've got in this folder are about loss. Particularly also members of Parliament. In fact, an MP, as an MP's sister had split she wanted half of his money, and he was using Parliament privileges to protect himself, so she couldn't claim the money, and she was at a grievance against Parliament. That's could cause distress to the individual. Loss. Well, she's at loss. She's at loss because the MP is using privilege to protect himself from having to pay the civil monies, which is why, they made it so they can prosecute them between sessions. This includes the petitions that could intrude into someone's personal grief or shock without their consent. You don't need consent, and this isn't. It's unfortunate. You know what the problem with this is that if this is like a village, they were discouraging people to get 20 signatures, so more than 20 people weren't seeing these petitions, right? Unless they went to court. Now, the court's going to hear the petition, right? And it's going to be officially in front of a jury in the court. So, people are going to know about it. Now they're wanting more people to know about it. Now that it's quite easy for people to, get signatures, they're asking for more and more and more and more and more and more to try and make it hard for you. Which the only result of that is more and more people have to see it and know about it. Right? So it's like they're demanding or commanding more people to see or know about it. Right? In order for strength of numbers. But they don't really want anyone to see or really know anything. Which is contradictory. So why set these ridiculously high numbers that people need to sign? Right? Why not just, have 20 signatures? They also want a website and they want things to be up there to look at. They can't just have what they want on there, and they can't only have the things that they like on there. That's just the way it is. And remember, these people in Parliament are the people who, Parliament burned down, and we've actually lost the full archives of all these documents. Some are on microfilm, or at least the details from them, not the original petitions, not the original pieces. The actual information was copied, at least statistically, onto some microfilm in the 80s, but all the ones from the 1800s till 1900s, I've just found out that they did transfer the data into a record, and those records exist, but not the original petitions. They didn't survive. So I'm not too sure what informations. They might have transferred all of them, the whole lot, but apparently there was millions. It might have took a long time for them to do that. Up till 1947, they didn't start saving them until 1947 again. And to be honest, there's a lot of people. It's usually because of distress or alarm why you do this and write it in. I mean, and this is the thing. People are getting this judicial system, these courts. People are getting prosecuted, for touching someone's leg or whatever, and they're claiming that the person's leg got touched and it was distress. People are suing each other in civil cases, taking millions of pounds off companies. Companies are getting rinsed left, right, and centre through the court process. This is court. It's almost. Do you know what they're trying to do? Do you know what they're really trying to do? This petitions committee is trying to pretend that it isn't what it is. It's trying to pretend that it isn't a very serious and unpleasant business, politics, and so forth. And they're trying to completely and totally say that justice has got nothing to do with it when it couldn't have more to do with it. And there aren't people who are rotting in cells in stench and stinking, or they've been arrested and they need to be let out, please, because they've got other civil cases to pursue. And they're trying to make out that, there is no bleeding Jesus with nails through his hands on the cross. And, some of these provisions here, it's a miracle. I'm surprised by these people who are in this petitions committee, these woke MPs, right? I cannot believe that Keir Starmer has not banned crosses in churches with effigies of Christ. with thorns on his head and blood trickling out because it might upset kids. Because these policies in this petitions committee, right, the way they're going with these YouTube-style policies, which aren't standing orders, they're not resolutions, it's not in law, they just pulled it out of the pocket from nowhere and said, oh, this is the new rules, right? It's got no authority at all. Oh, well, where Parliament, we've got the authority. No, you got the authority when you vote on it in law and when you pass a standing order and when you make a resolution. I don't see the official resolutions for any of these, right? And I'd like to see, you justify those resolutions when, the entire archives depend on it. It's almost like making a resolution for a magistrates court that we won't hear any criminal cases. We're not having any cases in this court where anyone's been hurt or injured, or if any companies are involved. It'll close. It's like Charlie Magistrates Court might as well close down. It's not a nice business. It's not a nice set of affairs. That's the point. People are getting sent to prison from these processes and procedures, and at the High Court have to pay a hell of a lot of money in the Supreme Court. They're wanting to. I'm waiting for Starmer to ban effigies of Christ. They've already banned praying outside the abortion clinic. I'm waiting for Starmer to say that it's too distressing for children to have Jesus on the cross at church. Therefore, we can't have any defamatory statements or unpleasantries on the Parliament website because it might upset children or grandmas or he, she, they, them. Or whatever, or Ed Davey might get upset because he can't use his pronouns anymore or whatever. But don't worry, Davey will wipe that blood off, Jesus' blood off your forehead and, and off your nice clean white shirt, you got it dirty, This is the thing, they're trying to make out this kind of holier than thou kind of thing. Oh, it's the children are going to be going on this thing, but the children got a magistrates court. They've got children's courts. Oh, I'm sorry, we're going to have to lock your daddy up for 10 years. I'm sorry about that. Chin up. This is the thing. Who are they fooling? These people are fooling themselves with this new kind of woke political correctness. And I want mine, but it's. They need to do some reading and history. I think these petitions that could intrude on someone's personal grief or shock without their consent. It accuses an identifiable person or organisation of wrongdoing, such as committing a crime. Well, I'm sorry. And they've tried to argue this, but they put the post office petition through to reverse the post office charges. And I don't care which way they did it, if it was put in the petitions bag, or if it was introduced formally or informally, or if it wasn't on the actual website, but they just did it in paper. I don't care. It's still petitioning Parliament, and it's still meant to be the same scope, whether you do it on paper or on the website. And the thing is that this is what the process is for, right? The process is for this. Read the archives. There are very few petitions in there that don't touch on this. Now, this is important. Now, it accuses an identifiable person or organisation of doing something wrong, right? Such as committing a crime. Well, check this out, right? This is because this is a complaint that needs to go to the Attorney General, right? 155. This is actually standing orders now. This is actually standing orders. So these are the rules of Parliament. These aren't like, incense and crystals of the pretend rules that aren't rules. That no one with authority or jurisdiction to make rules made rules. Standing orders are the rules, right? A resolution is the rule. Passing a bill is the law and a rule. Sitting in the petitions committee, twiddling your thumbs, even if you're an MP, right? And coming up with rules, even if the committee vote on them, right? They're not enforceable if they're actually stopping you doing. You see, they're cutting into the law and the right of the subject. Effectively, what they're trying to do is they're like saying, "Oh, we'll go fishing to a lake, but you're not allowed to catch any fish," right? Or this is a fishing lake, but we're banned rods, right? Or we're going onto a football pitch, but you're not allowed to bring a football on there. But that's what we're doing, right? And you can only be so stupid until you realise that you can, if you're polishing a sculpture, you're cleaning a sculpture. But if you're chipping into it with a chisel, soon there's no sculpture left. They're cutting into the petition process that much that they want it to appear so, innocent and Lib Dem, Green Party kind of fluffy, or like some kind of toy shop, that don't want to offend anyone. Yet they don't realise that what they're doing on a daily basis in Parliament is torturing people with their policies and making things in law that are hurting people, hurting them, making them so they can't afford things in their lives. And they're just kind of like, because, Tony Blair, or it's someone else's problem, because they're not immediately there. Well, people are immediately there because they're outside, chanting with signs. I really don't know who they're fooling. But anyway, here, this, right? So this is actually 155 is a petition has to present personal grievance. So you yourself have a grievance. Now you have to have a grievance against someone, and if you can't explain what the grievance is or who's done it, then it's not a grievance, is it? It's almost kind of like in civil suit, right? When you go into civil court, unless it's in America and you're doing like a federal question or whatever, you got a respondent, right? You've got a respondent, and the judge is impartial, right? The judge is impartial, right? Now, you can have like King's Bench when it's, you've got a grievance against the state, or you can have common pleas, right? Which is like you versus another party. The House of Commons petitions is meant to be anything that could arise, right? Now, if you had a civil court and you say, well, you can lodge a case here, but you can't have a respondent, right? It can't be, you can't claim that John owes you £50, right? You can go in, you can say, I'm owed £50 from who? I don't know. Where did Jesus come from? God. It's almost like the Bible. Hello, Your Honour, I'm owed £50. Who owes you this money? I can't say, Your Honour. Well, have you got any evidence to show this? I could show you the evidence, Your Honour, but it's their personal belongings, and it might, and also I would have to mention about the can of Coca-Cola that poisoned them, and that's defamatory against Coca-Cola. So, no, I can't offer any evidence. I've got no evidence to offer. I offer no evidence, Your Honour. Well, I'm sorry, I'll have to, I can't have this case here if there's no respondent and you can't show any evidence or nothing. It's what they're actually doing. they're actually deactivating you. There is no petition process, really. It's pretend now. It's kind of like it's almost like replacing a sex partner with a rubber doll. You're not really having sex with a person. You're not really petitioning the government. You're not. I'm doing it. I'm having sex. No, I'm petitioning Parliament. Well, it's it's kind of like having a toy boat. This is not a boat. It's almost like a teddy bear, but it's not a real bear. Or a rubber chicken, and you're going to eat it for your tea, but it's not edible, This petition process, how can you do anything with it? And the amount of signatures you need, it's hard enough to get them to accept it if it's something, safer than safe, which effectively means that, it can't hurt it's not going to be detrimental to Labour, it's not going to be detrimental to the Conservative Party, it's not going to, no one's suffering here, Every member, in the case of petitions presented under Standing Order number 153, presentation of petitions, right? Complaining of some present personal grievance for which there may be an urgent necessity for providing an immediate remedy. Oh, you can have that. Something's urgent then. The matter contained in such petition may be brought into discussion. Can you believe that? May be brought into discussion on the presentation thereof, and proceedings under this order may be proceeded with though opposed. Until any hour. Right, so actually it's looking like if you actually have got a petition which is a grievance, they can actually act on it, they can expedite action on it, which might mean that you might not actually have to get 100,000 signatures if it's quite important, serious or urgent, but only if it's actually a grievance, which that's wrongdoing. So if there is wrongdoing, they can action it swiftly and quickly, right? But you still might want to get some evidence, people to support it, to show, because it might be important to you, but they might, who is it important to? This is the thing. You're proving how important it is by how many people support it as well, and the weight of public concern. But the thing is, they're not wanting people to see or hear these grievances and to know that they're quite serious, because they might not act on them, they might not expedite them, and they might not do anything about it. But if people, 100,000 people sign it and know about it, then they bloody well might have to. And that's the thing that they can't come to terms with. But what they're doing is they're actually trying to make out that you cannot have a grievance against someone. You can't have you can't bring a civil case without a respondent, that's for sure, because there is no case. The justice is impartial and there's a respondent. Now, the petitions committee members, they are acting like the justice and the cabinet or whatever. You got your chair, and the committee members. Now, it could be against another member of Parliament. It could be against any member. And I know that they've got the health and parliamentary health ombudsman, who you can complain about MPs to. But if you could get it sorted out through Parliament and the Privileges Committee, why would you need to go as far as the ombudsman? You know, he's meant to be the last resort. And if these are all privileged people, they're meant to be disciplined by the Privileges Committee anyway. So you wouldn't be going to a normal court unless you want to prosecute himself between sessions. But why would you, why would you pay to do that? It's like the difference. To me, I think it's like the difference between getting a GP or a private doctor. You know, you can go private but this is going to be provided by the government. You know, it's government service. And, you know, I think the party politics really messes it up because you've got people as members of the same party, you know, birds of a feather stick together. But you might be another entity, group or person. You see, really, you really should be able to complain to Parliament about Coca-Cola if you wanted to, or McDonald's, and say that, you know, everyone's getting fat and overweight, and, you know, you want to stop allowing planning permission for them in the country. Make fast food chain planning permission illegal, you know. Remove the powers of local councils to be able to do it. Now, they might say, well, you can do that without mentioning any particular brand. You know, you can say, well, just fast food chains, but it might only be one of them, you know. It's inconvenient for the fast food chains that someone has felt they need to raise them out to Parliament and get 100,000 signatures, which is not easy. It's not in the High Court, but, you know, even they're going to, you know, if anyone can take them to the High Court, and those files can be looked at the High Court on records. They're trying to even cover up all the case numbers for the Magistrates' Court and the Crown Court now. We only make it available for, like, you know, the day before and the day after, and then they vanish and disappear because they don't really want people to see them, but they will see them. It's like the inconveniences of, you know, being McDonald's or KFC. Well, it's not inconvenient for them because they're multi-billionaires, you know, but this is the thing, you know, some people don't want to be famous, but this is the thing, people can end up in incidents and end up in a newspaper or on the news anyway. Most people try to avoid it, but this is the thing, you know, some people love going on calendar news and they're like, oh yeah, you know, a bomb went off in my neighbour's garden and we had loads of loud noises and whatever, and, you know, they're straight on there on calendar news or whatever, you know, or, you know, my son's run a marathon, you know, he's made a world record in marathon running or whatever it is. You know, it's whatever floats your boat, innit? You know, some people end up victims or caught up in cases when they didn't intend to be, and that's tough, but it's like anything, isn't it? Most of the time, though, I think that most of these petitions on that website are usually quite serious national things that are quite important to people, but we'll get onto that in a minute when we get onto the silly, the part that says you're not meant to do silly or joke petitions, which people do try put through. But so there is actually the thing is, right, in standing orders of Parliament you can petition a grievance, which you can't have a grievance. The model for petitioning is structured around the complaint, because it's the oath and the prayer and the complaint. A grievance is a complaint, right? And the complaint is the affidavit. Well, the affidavit part of it's the oath, but it's the complaint. If you get the 18, we've got all these written out in all through the acts of law, all the way through history. You know, Parliament have got all this data, right? The prayer is the part that asks for something. You can have a complaint without a prayer because you might not be asking for anything. You just might be reporting the complaint, right? You can report an MP without asking for anything to be done about it, you know. So that's wrongdoing, but it's not necessarily saying that, you know, you want them sacked or they should leave, right? But you're letting them, you've got a legal right to, if an MP's, if he's selling drugs, at his surgery when he's meeting his clients, then you must report it into Parliament. You've got a legal right to. Now they're not going to want that on their petition site or whatever, but if no action was getting done about it and nothing getting done about it, like Jimmy Savile protecting them, you have to compel them with the weight of the great public concern, which can only be done through the petition with signatures. So, that is the way that you do it. And we know we've got all these council monitoring officers, the Health and Parliamentary Service Ombudsman, and blah, blah, blah. But the way to do it is by a hell of a lot of signatures, which is evidence of great public concern. I guess they could have done that with Jimmy Savile, probably while he was still alive, For example, this is the thing, Tony Blair. There's a petition with Tony Blair with, millions of signatures, but they wouldn't have it on Parliament website. They wanted it on change.org. But it's a lot more legitimate when it's on Parliament website, and all the postcodes are all logged properly and everything. You've got a legal right to do it, and that is one of the things that it's created for. And they're trying to kind of remove that from it when you look through the archives and see what it is actually for and what the point of it is. You see, they've got all those different categories. They put the petitions into different categories like religious, tax orientated, and so forth. And then they had miscellaneous ones. I think they probably didn't really want to actually say, complaints against members or whatever. I've got a petition here which, you've got this woman and she's a sister of an MP and, she's wanting to take him to court to divide the money up, in a normal court, not want Parliament to make an order on it, but she can't take him to normal court because of Parliament privileges, right? Never mind, it'd been all right if she could get an injunction or something to stop him going into Parliament and being an MP, but she can't even do that, So I don't see why they get these injunctions interfering with Parliament because, you could get, how about getting an injunction to stop him? If you can take them to court in between sessions, you can't get an injunction to stop him going back into Parliament again and continuing being an MP and continuing standing again, This is the thing. But so you can do grievances, and where they're saying that you can't, they're lying because that is wrongdoing. It's a complaint. You can have a petition with just a prayer on it without a complaint, but most have a complaint and a prayer, and the oath is the signature, and that's what the affidavit really is, the oath and signature. Sorry, the affidavit. If you look at the word affidavit, what does it mean? It means oath. So the oath part, when a police officer, you're actually putting the complaint in, and the police officer's logging it and getting witness statements and so forth. But when he signs it and sends it through to the court to get the warrant or to get the CPS to prosecute, he's adding his oath to it as well, and you've got to put yours on it, which is what makes it the affidavit, only that he's swearing that it is the truth. It's the swearing part that, you swear that everything you put is the truth or to the best of your knowledge. And that's what and the fact is, what they're actually doing on here, they're trying to say that you can't actually submit evidence unless it's already been proved, but you're submitting to court with your, sometimes you don't know. You're trying to prove it, everything to your best knowledge is the truth, including your statement. But how does anyone know that any statement is the truth or not until it's been proved? It's kind of like, can you imagine that if you had to, it's almost kind of like going to a court to get a jury to prove that your statement's true, and then going to court then to try and say that you're not guilty because you proved that your statement was true. But if you prove that your statement was true, you won't be in front of a jury, would you? It's kind of like it's Tory party con. It's like it's charades. It's Conservative Party Tory spin. It's utter lies and charlatanism and magician tricks with complete and total lies of policy in order for them to completely diffuse and deactivate really any decent chances you've got of beating these people. I mean, they think, oh, they won the election, so what? Look through history at what was happening in Parliament and going on. You know, there was... we don't have any... Well, Lord Hindfield went into prison, but through the wrong processes and procedures, really. Although his own peers can send him there. But if he's still meant to be working, he shouldn't have been in there if he was still a working Lord, still working in the chamber. It names family members of selected representatives, example MPs, or official public bodies. Well, that's untrue because in that case that I just mentioned, that woman was naming herself. It was the MP's sister, and she was self-naming herself, saying that, oh, the MP's my brother. But they're trying to make out that these rules, right, of kind of like, I get the impression, or it's my belief, that this current Parliament and this current staff of the Commons are trying to pass these off as if this is the way it's always been, right? You know, petitions have never had any of this stuff in these rules in them ever, and they aren't anything to do with the petitioning process. You know, Parliament has always had this, you know, the right honourable gentleman business, and, you know, we just don't do this and never have done. Not the fact that, you know, oh, we suddenly got woke and, you know, we suddenly got woke, or the fact that we suddenly got an online website and then, you know, it's a bit awkward now. Not the fact, well, that's what it's there for, you know. There's an online civil claims form and court, but, you know, that could be awkward for people, but they're still doing it. Well, it's fully confidential, you know. Well, maybe they need to make it confidential. Maybe these things are so serious and people have got rights to bring certain causes that maybe you submit it to the Parliament, you know, and the committee can see it and access the files, and maybe, you know, you have to print it off and just walk around the streets and, you know, do a bit of advertising and collect the signatures and then, you know, upload them or whatever. Or maybe you shouldn't need 100,000 signatures. Maybe it could just be done with compelling evidence, and then you don't have to show it to everyone, you know. Maybe they have to do, you know, certain criteria. Certain petitions which, you know, could be deemed showing sensitive, but, you know, you're meant to be. They are the ones who have set the bar so high that you must have 100,000 signatures. They're saying that 100,000 people must know about this cause, but they're also restricting how much information you can write. So you can't really show us much, or you can't show us anything, but in the most serious and important things at the highest level of government in the world, the most serious and important cases. But they're trying to make out that they're not, that they're just kind of like, we're sort of being treated like the Monster Raving Loony Party club, but which is not serious, or like a Monster Raving Loony Party by-election, like, oh, you can participate in politics, but don't worry, you're probably not going to get elected. There's no chance of you really getting elected. It's just for fun. And, you know, unless you're Laura Corrigan and you've got a lot of college student mates knocking around and they can pull in 100,000 signatures, or you happen to be in a really big Facebook group, you know, with like 80,000 people who will, you know, just throw themselves at it, you know, belly flop onto it and just, you know, but they never do if it's serious or important, or only if it's something like, you know, block Donald Trump from England, or if something's in the news and the like a police officer runs a cow over or something, and everyone's ringing the RSPCA up. If it's actually something effective that actually would be good or useful, then it's very difficult to get signatures. It asks for someone to be if it asks for someone to be given. So we got to this one now. It says that it asks for someone to be given an honour or have an honour taken away. You can nominate someone for an honour here. So they're really trying to stop you from doing that online. But they've got a committee for forfeitures. They've got a forfeiture committee and a committee for honours. So they've got committees for giving honours and taking honours. Now, the thing with the standing orders of this committee is that it can pass matters to any other committee, right? They can pass them to the other committee that's relevant. So, really, through law and under the standing orders, I can tell you which standing order it is. There's a legal right to petition what can fall into the category of any of the other committees. And the reason for that is that they don't want... It's like the Tony Blair petition with 1 million signatures to take his knighthood away. They had to do it on change.org, but I still submit to the forfeiture committee because they really just don't want people signing it. And do you know what it is? They're happy to have people collecting at the ballot box and to have it official and on the bit of paper. You want these people in, but they don't want it for out, and that's the thing. And also they might end up, getting certain persons' honours, like God knows who, I don't know, Neil Oliver might end up there wanting, they might end up getting Neil Oliver a knighthood on there, but why not? I mean, I don't particularly care either way myself, but what I do care about is the law. And they've got these committees for culture, media and sport, committees for privileges. The privileges committee is meant to engage with this committee, and when there's any matter of anyone getting prosecuted when they're meant to be covered by privileges or out there sharing petitions and handing leaflets out for it, it's meant to go to the privileges committee, but it's not doing in the Attorney General, and it's not doing. And the same for these honours and so forth, and like with the Tony Blair, because they just don't. They're trying to block you from doing it. Yeah, they've got. If there's a committee for it, then they don't want to help you. Basically, the thing with that website is that they're kind of like giving you a helping hand by having it on there and making it shareable, but they're actually not helping you. They're helping themselves just because they get to validate all the information and check all the postcodes because it's a lot more legitimate than unchange.org, right? But if they don't want anyone to be dishonoured, then why have a forfeiture committee? Why have a committee for it? If it's that bad, why have a committee for it? This is the thing. And then they don't want people to end up getting honours who might outdo or do better than the Tories. And also, they always teach that the Prime Minister decides who goes into the House of the Lords, apparently the Minister can make Lords, only the Prime Minister can do the honours list or whatever. But yet there is an organisation where you can, make recommendations for honours and so forth. But you can definitely, if you voted for people, I think, I'll tell you what, there's some petitions that I've been reading about in the archives to do with, it's quite a well-known study case to do with one of the MPs. And he ended up, the Parliament decided that he hadn't been elected, and another MP had, who came second because of a certain couple of disputes and arguments. And that's a good example. He'd actually been elected, and then Parliament said no, he hasn't. And then the people complained that they got a right to their choice of MP that they chose. You know, he was the one that they nominated. They had a dispute over that. It's kind of sort of similar, because the people had given the honour, and then the Parliament said that he hadn't been elected and that the other one had, so they kind of took it away. If it's only the monarch or the MPs, but they're putting the pals and buddies in there, aren't they, into the House of Lords, like good little Tories and good little Labour people. But, you know, they don't really want to allow independents to get positions in, because, you know, what this other 1/3 of the country who don't vote for any of these major parties might end up suggesting some people, you know. So I'll have to read up on that, what the tradition is. I haven't noticed any petitions asking for honours, but usually I've seen plenty of them complaining about MPs and plenty of them getting punished or having their privileges waived or whatever. And that's the reason how you can have an honour removed if you've, you know, been convicted or found of a crime. But there's a couple of MPs who've been headbutting people and punching them. One more recent, one a bit longer, that guy from Falkirk, who was a member of Labour. They ended up staying in Parliament for quite a while and keeping their privileges. You know, it protected them, so they don't necessarily lose their position. But I don't think that they had knighthoods or anything like that. If there's a committee for it, though, really, it is within the rules. Right, and if people know that, the model and structure of it, then everyone would question this. We'll move on to the next one now. It asks for someone to be given a job or lose their job. This includes petitions calling for someone to resign and petitions asking for a vote of no confidence in an individual minister or the government as a whole. Well, why can't you call for it? Well, the thing with that is, what is a referendum? Referendums are meant to be actually in law something that you can petition for, which is the vote of everyone to do something with the whole country, whether it's to leave Europe or something big or important, or even change the system of government. And the thing is, in local government, you can actually write and draft it almost like a bill. You've got a blank sheet of paper when you're proposing a bill in Parliament, really. The petition is meant to have the same potential as a blank sheet of paper or proposing a whole law or bill, even in local government as well, or even how you can have a referendum and how it should be run, or even what days it should be on. Apparently, whatever you can write down and suggest to make something into law or a process, any electoral process that is imaginable or possible. Obviously, what they're saying is, you know, you can't ask for someone at McDonald's to lose their job. But what you could do is, this is the thing. This is why you need a lawyer and someone who knows about law, what they're talking about when you tackle these rules. Because if you think about it, you can petition Companies House. You can petition about Companies House, and you can petition about certificates. You can petition about limited companies. You could petition for, if you wanted to petition for Parliament to withdraw McDonald's certificate of a limited company from Companies House. On what grounds? Well, because whatever, for providing ill health food. If 1 million people say that, or 60 million, or whatever, then why not? People have lost a driving license for a lot less through criminal or judicial procedures. At the end of the day, the thing with the criminal process is actually a complaint. There are laws that exist. Someone's broken the law, but it's a complaint that someone has misbehaved and broken one of the laws of the country, and they'll be in front of a jury, and then we'll say what these laws are, and then we'll show the evidence, and then based on the evidence with the law applied, the jury decide whether they should be punished or not, but they can also be forgiven, right? It was a complaint against the person, and then the peers, the villagers, hear what happened, and they decide whether they should be punished or not, right? But there's always the chance of forgiveness. It's a complaint. This is what it actually is, right? Now, why can't you complain against a company? You can complain against the driver who's been driving around like a lunatic to the police. This guy's been driving around like a loony. There were laws. Well, what kind of law? Well, he's careless, reckless, dangerous, just fast, or driving too slow could even be dangerous. Well, he's driving too slow all the time, but I think it's dangerous. It's a complaint, right? It'll fit into one of those laws here, there, or somewhere. Well, you know, you could, you know, you can even have a complaint against the police for the company, you know, making food dangerously, you know. But there are various other health things that they can have civil actions for, but not be prosecuted, just like building regulations. But, you know, why not have their certificate withdrawn? Can you even withdraw a certificate? Unless, apparently, only if they don't pay their money. But, you know, what you know, there could be powers to revoke a certificate. A driving license is just a certificate where it has points on it. I know that doctors have certificates, and if they don't act or behave properly, they can have the certificate revoked, particularly if they've committed a crime, or possibly even if they've had a civil suit. But it's something that the government issue, like a driving license, any certificate, maybe, but it's not privileged, though, is it? You know, this is the thing. But you can use a driving license under privileges, and you can, I suppose, you could use a doctor's license under privileges if you were doing some kind of investigation into some disease or something. It would come into it. You know, if you had to prescribe something in order to prove something or get some evidence, you know, maybe your patient, maybe you could prescribe your patient certain medicine, and they want a volunteer to prove that, you know, we shouldn't have that medicine, possibly, where otherwise it would have been dangerous to prescribe it. Maybe that on that occasion, if you're privileged, then you won't get arrested or you lose your license. There's lots of different things. They're not very creative, these MPs and politicians. They're very creative when they want to try and censor and restrict and inhibit and block our remit. But when they want to, you know, when they want to, it's all in their favor. It's usually in their favour, I think. Yeah, I mean, a random other citizen losing their job who doesn't work for government, you know, that's kind of more like you're picketing, isn't it? You get into picketing then, and, you know, almost like, you know, it's like that's the difference between like a normal protest for, like, you know, let us back on some kind of O2 Arena gig. But I actually thought about it when you get to football. You know, is the England match a matter of state? The Olympics, the Olympics is like meant to be on behalf of the country, the England team there, so it's a matter of state. So could an Olympic stadium be a matter of state? You know, let us back on to the England match in football is a matter of state. But, you know, usually a local football match is not. Some football could fall under matters of the state, but not all of it. It depends what match it is and what tournament it is, and if it's the Olympics or not, you know. But most private businesses and companies and affairs between employers, it's not matters of state. But you're getting into all that Labour Party stuff, then you're getting into all the what do you call it? You're getting into the unions, employment union stuff and rights. Ask if someone should. All right. So the job one. Well, they asked Boris Johnson to resign, didn't they? Boris Johnson resigned because of what he did and because of complaints. So I think that Boris Johnson incident could disprove this rule from being legitimate, really. Think incidents like that could because you can't have the whole situation where Johnson is up in front of a committee and then he has to stand down through what he did with COVID, and the public pressure really is the petition, because that's almost kind of like when you're trying to say that because someone hadn't written and submitted a petition that they're not actually doing a petition to government, but yet they all seem to be writing into the government or ringing into the government or just talking about it on social media, and it gets a reaction and the news talk about it, and then Johnson is under pressure from what? If there's no petition to ask him to resign, but he ends up, you get a government action where a committee then has him in front of them, and then it ends up resigning. So how did it happen if there was no petition? Well, that was through public remonstration. So that proves the basis of the 1661 Tumultuous Act, that you can have the same result that a petition would get from not actually having a petition, just through public remonstrations, which is public pressure, whether it's through the news media outlets, the main news channels talking about it, and people discussing it in public on social media, writing letters to their MPs, complaining to the government, but they wouldn't let you have a petition up on the Petitions Committee website with it all, just all the signatures down together, that did all the talking on the TV shows, the social media talking, the in the streets, the news media outlets, the GB news programmes who are cussing him, and all the people writing letters to the government. They don't want to put it all in one file on one folder with a ring binder through it and say, Johnson files, and, you might as well have been a petition on that website with all the signatures nice and neat together. Johnson should resign, and then he's always in front of the committee. Surprise, surprise. Same place, different route. Instead, you've got all these separate letters, all those separate MPs, all those separate TV programmes, all those separate social media channels, all the people walking through the streets with the banners and so forth and so forth and so forth, all the time, all the money, all the paperwork, all the letters, all reading of the letters. Same thing. It's almost like on Dr. No, when he's like, Quarrel, hey, you Quarrel? Yeah, man. And then he's like, can you take me out to, Dr. No's island? And no. And then he walks the other way, he walks off, and then Bond walks the other way around, and then they both meet at that little cocktail bar. And he goes, oh, funny, I should meet you here, Oh, it's Johnson. Funny Johnson should be in front of the committee for privileges, standing down. Well, we can take this any way you want. Why not just might as well have had it on that Petitions Committee website, Well, you can't get any more humiliated than, every single social media outlet talking about it. GB News, talk radio, everyone in different Facebook groups, and then signs outside Parliament saying, get Johnson out or whatever. You can't get any worse than that. So, it's like you might as well have had a petition on there and just simply in writing and just get people to sign it. Clock up some numbers on there. Why they blatantly refuse to do it, I don't know. It's something we can't do. Well, that's a lie. It's something that we can't do, something a committee can't do, something Parliament can't do. That's a lie. That's a lie. That part is a lie. And it's as much as a lie as Johnson. We'll move on to the next one now. It contains party political material. Well, the government aren't meant to be for or against a party, right? But if we are independent, we aren't a political party. Now, an election is party political. Elections are organised and run by government, but they're not meant to be. The government's not meant to persuade you for or against. Now, this one is you solve this through the referendum, right? Because the referendum is a referendum is a process which the government are going to pay for, facilitate, and organise, in which they must be impartial, and the public will go and vote, and they're not allowed to influence the public either way. To obtain that, you do it by petition, okay? The petition's not a referendum. The government are not... Well, the government... The petitions committee has to exist. There has to be a parliament, right? Okay. But the petition committee website, the government are doing that for you, you know? They're providing it for you. So, but you know, they provide a committee. Other petitioning sites are available, you know, like change.org or whatever, but you end up still delivering it to number 10. It's not like they've boarded the door up and they're not providing, you know, the doorway or whatever, or the guy to hand the box to, right? But what is going on is that you have to... The Parliament aren't getting the signatures for you, although it helps having the website, because if you're on the front page of the website, you're kind of getting a bit of free advertisements. But then again, once it's live, you know, you're getting a bit of an advertisement having it on the Parliament website, because people go in there and look for them. But once they get so many of them and they kind of get a lot of them and people can't see or look through all of them, then only the ones that are doing well or getting the most signatures get seen, the popular ones. Well, that's populism. That's that is in a way cheating. Because if they're using populism or petitions in order to... It's like a competition. They're running a competition, really, on there. All of them should be equally accessible or searchable under what the subject is, without any form of ranking or any prioritising or anything at all. So, in a way, it is a little bit cheating by having a front page, right? But they're not actually getting your signatures for you. I mean, you know, if you've got other notice boards somewhere. I mean, if it's the village notice board, everyone in the village is going to see it. So it's the point of it is to advertise. But then they're not actually, you know, they're not going out of their way to ask people to sign it. But they're providing that it exists, that you can do it, right? So, but everyone's got an equal... There's an impartiality to a notice board that, as long as there's space on there, anyone can put a notice on. But then if some notices get put over the top of other notices, then you can't see them. So, like, you know, how the Petitions Committee website kind of is running, I suppose, is like a notice board with a very, very, very lot of petitions safety pinned on there or pinned on there, and a lot of them then get covered up. So people are only seeing the ones at the front, and then they end up getting the most signatures. People don't always come bothered looking through them all. So there is a bit of impartiality about that. There is a little bit of unfairness about that. If they were all kind of like sideways on, so you couldn't see them, and if like they all had like alphabetical order, like a library, like, you know, when you see the sides of the books and you don't know how many people have signed them, but they're all in alphabetical order, or like in agriculture, like fishing, taxation, and so forth, then it would be like walking into a library, and then you just look for the section that you're interested in, and then look through the side of the books, only sit on the side of them, like the subject or whatever, and then when you pulled it out and then you see how many people have signed it and what it was about, then you could sign it and then put it back in again, right? But but they're not. They're ranking it. They've got a ranking order on it, right? So in a way, it's kind of unfair, because you've got certain people have got an advantage. It's advantageous, and that's what 38 Degrees are doing with the money. But they're providing an advantage in a similar way, but monetarily, by which petitions they choose they're going to finance and assist through financial support and sharing in emails, which is equally as bad as Parliament doing that. But mainly for the petitions, if they didn't have the website, and you know, and it's like number 10, you know, or you know, once you hand them in and lock the door, you know, no one can see them. You've got to go out of your way to do it. It's door knocking, and it's just word of mouth, or your own money to get it in a newspaper. And the newspaper's going to be impartial and not block anyone from publishing it. And this is when we get into YouTube, by the way. This is where we're going with YouTube and Facebook groups and so forth, publishing and sharing. the courts can ban people from publishing and sharing certain things, and MI5 and Parliament can remove things with powers. These are the powers that the committee are meant to engage in and have as well. But we've got a legal right to share and distribute without being stopped for this. And this is where in America you get your First Amendment, your freedom of press. You've got the press we must be free to be able to make use of it, because everyone has to have the press have to be impartial, kind of, really, like a judge in a legal case, that they're not allowed to favour any side in the public notice board, because really well, if it's a petition, they're not allowed to say no, really, and you can't be prosecuted, and they can't be prosecuted for putting the petition in, because of all that parliamentary defamation protection stuff and copyright stuff. So no one can bring legal action. So they've got no reason. They've got no reason to reject it, because they don't need the night lawyer in, and to check it all to see if it's legally sound, because all parties are protected. The person who's petitioning is protected, the people who are sharing it's protected, and the newspaper are protected. You don't actually need that law they've got in America. Like in America, they've done all this fancy law for YouTube, so they're not treated as they will never be treated as the uploader of a material, so they can't be liable to civil suit, right? But you don't need that if you're doing a petition, because you can't be arrested or prosecuted, and the newspaper can't be arrested or prosecuted for publishing a petition, and you can't be subject to defamation or copyright. So why would they say no? There's no legal reason to, because they can't suffer. They can't suffer consequences legally, so they've got no reason to not let you put it on the notice board in the newspaper, right? Unless they're trying to stop you from getting the signatures. Now, this is impartiality, and that's unfair. And the notice board section is meant to be open to everyone, which is meant to be your freedom to access the press, right? Freedom of press. Press is free for everyone. Because, otherwise, like I said, if you've only got one printing press in a village and there's 5 candidates and they refuse to publish the adverts for one candidate, that's effectively they're trying to block someone from being in a fair, open competition and people reading it. This is why we've got a legal right to do it. How do you enforce that? Well, I've got an answer for enforcing it to be published, to compel it to be published. And this is what I think compels it to be published, really, on the Parliament's own website. And that is that if a courts or judicial authority's got the powers to stop something to be published, what about compelling something to be published? Well, can you do that? Well, of course you can. There are loads of examples of compelling publishing. There are multiple acts of law that says a copy must be published in the London Gazette and at least one major newspaper for like roadworks for local council authorities. The government must publish certain projects in at least one circulation of a newspaper in the Gazette, blah, 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 blah. They can't stop them from doing it because the law says must be published in at least one newspaper. And to be honest, these petitions, like, the ones that get read out, get enhanced. I've had this argument with the Gazette themselves. I'm like, can I put a petition in the Gazette? Well, this is the thing. You used to be able to put them in there, and then it actually helped make it official. But then they said, no, we don't do petitions when they're lying, because if you look back in history, they were doing them in there, but they didn't want to help us out or have them in there. But you don't really need it in the Gazette when it's on the Parliament website, because it's official. It's like the notice board for England. The police can just check if it's you don't have to put it up in a police station, because they just check on the government website, because it's the government website, innit? It's the easy access notice board of the country, for anything central government. The police don't need a copy of it on the police station, because they go on the website or the government website to see what's listed on there. It's like checking the court listings, check the magistrate court listings, check the HM government petition listings, it's the same thing. effectively. It's just like checking the court listings. It's like going on that court serve and checking, all the magistrates' court listings. It's just like going on the petitions website, Why would you need a certificate from the Speaker of Parliament? Well, it's if they don't, if you need further to convince them or compel them, usually, but it's meant to be carry more authority or more. It's meant to be more convincing or more, if you're having trouble having it recognised or whatever, to assist with recognition, to certify. It's a certificate. In the Samuel Johnson Dictionary, under the word certificate, it's a document from a court or for a court. It's actually a legal document to certify something legally in a court. And actually, even your swimming certificate, most certificates like health and hygiene are effectively there if anyone legally challenges you, so you can prove something. Ultimately, not a lot of them end up being used in court. They end up in a frame on a wall. But it's actually there if you're legally challenged. That I've passed. Here is to certify that I'm legally sound or I'm legally licensed. Although people don't always have to use it in court, it's there for if it needs to be used in court in many instances as what to certify. To certainty, it's the certificate is for certainty, right? Now, if you've got a petition on the petitions website, then you can be quite certain that you're doing it and it's been approved if it's live, and it's not easy to get one live on there and running because if they're rejecting a lot of them, you can be certain that it's official, right? Unless it's a fake website, right? So there's great certainty to it. If you can't be certain of that, then how can you be certain of any court website or anything? How can you be certain that you're on your own Facebook page when you're on it, or that your friend on Facebook's your friend? This is what they're having problems with now, a lot of fake copying profiles and so forth, and things like that, But the certificate is for certainty, and if it's from an authority, but then again, this is what juries are for. Sometimes you can never be certain in the court. It's reasonable doubt, but that's the standard that we're running the country by. A certain degree of certainty, a certain amount of certainty, or else no one would believe anyone with anything. You wouldn't even believe that you got an apple in your hand when you were holding one. You doubt it. You paranoia. It's certificate from the Speaker would be almost certain, beyond certainty, in addition to having it on the website, if it was a legitimate thing, it gives certainty to it, So, contains party political material. So that's what we're talking about, party political material. Well, yeah, so there are powers when something... what gives... Right, when you're publishing something in a newspaper, right, and I said that, there is certain legislation and acts that say that, it shall be published in at least one main newspaper. Well, which one? Well, I guess they can take the pick. The newspaper has got a legal obligation in the law of England to publish certain things the government send it, right? And the petition is something that you're running with and through the government, right? And you can't be prosecuted. It makes you wonder, can you go into the newspaper printing press and, knock yourself an advert up and just run it through and say, I'm putting it in, without being prosecuted? That would be an interesting thing for Extinction Rebellion, insert yourself into the newspaper. That's a good, interesting question. But they've got no reason to reject it unless they're politically opposed. But if they're meant to be a newspaper where anyone can... You see, we've got all this fair trading standards law now, consumer rights and fair trading standards. And under consumer rights, they're meant to treat consumers without discrimination. And this is when we've got all this gender, sex, religion, all those traits. The government are meant to have a trait in there. There's supposed to be a trait for not having a political discrimination, or at least not for certain things that are essential services, because then Royal Mail might refuse to deliver your letters. Now, Royal Mail is meant to be owned, it's meant to be King Charles's, it's meant to be the royal family's mail, it's meant to be the government. It is the communication method of the government. How did all the justices communicate with each other? How did the sheriff communicate with the king? How did the bishops communicate? It was the Royal Mail for the government and the peers appointed. It wasn't for us and the common people, unless you've been arrested, and then you get the privilege of, maybe, I don't know if you paid or not, but sending a message or petition to the king, whatever. Now, therefore, you've got a right to use that mail, because you right to petition the king. It's Royal Mail. It's a right to petition the king. It's Royal Mail. So you've actually got a legal right to use that mail system to send the message, right? Now, what happens when they sell that off to a private company in Germany or DHL or whatever? Well, there are certain rules and regulations for elections where electoral candidates were meant to have certain free access to the mail through Royal Mail, send so many letters for free without paying, and there was legal right to do that, and they couldn't reject it. What happens when you sell them all off to these private companies like Mark Zuckerberg and Google and so forth, and even the King's Mail? What's he left with? Well, they're meant to have contracts and policies and agreements with the government, and they're meant to, it would be, if David Cameron sold off Royal Mail and then the Royal Mail said, oh, by the way, we've got a new policy, we don't deliver mail to Parliament or to doctors or to court, or we don't deliver medical letters, then, your alarm bells are going to start ringing with Cameron. He's going to go, well, okay, I roll my sleeves up now, and okay, you can't refuse mail for medical and doctors. I'll have to put some legislation through where you can't refuse mail for doctors, even though you're a private company, But it wouldn't have been refusing the Royal Mail. But you'll find that the consumer rights kind of kick in, because, the men to treat all customers with, fairly and equally and so forth, and all that. Why aren't they delivering you mail? Because it's medical mail. Well, are they discriminating between medical mail and other mail? It's not a protected trait. If you were black, or if you were Chinese, or if you were a Buddhist and they refused to deliver your mail, then, you're kicking into your discriminatory traits. Actually, there's meant to be some other traits, because there's meant to be certain political things which have a necessity to be delivered under government, or even a right. I think that those particular core fundamental things which would have usually fallen under the King's remit for the King's Mail, they must surely must be enforced and adopted by the new organisations that have taken over them, because they're like core services and functions. How I've worked it out is that the right to petition is the right to petition the king, and all prosecutions and commitments for doing so are illegal. Well, arrest and imprisonment, but you might say, well, that doesn't compel someone else to do something, even if they can't arrest or prosecute you. Well, I don't know. Maybe you could put your mail in the letterbox without paying or whatever, if you're not liable to be arrested or imprisoned, but they might just not deliver it. How can you make them deliver it? How can you make YouTube or whatever publish? Well, the thing is, you got these standing orders of Parliament. They're actually called orders, standing orders. It's almost like military standing order, Now, the Petitions Committee runs through those standing orders. Some of the standing orders compel witnesses and information, like a subpoena, right? It is a subpoena under the Parliament jurisdiction, effectively, when they summon people or information. Now, this is the thing. If you can compel information, right, they can take information down and block information. Now, to compel information and say that this information must be there, this is the argument that I was getting with the screen printers who wouldn't screen print, the stickers to advertise the petition, right? Because, like I was arguing, the tax money, that it was tax exempt on Group 9 non-corporate body under a political entity with a political objective, which is one of the exempt groups in the Value Added Tax Act 1994. And the thing is that, so when you're summoned, they're compelling you to attend. That they're saying that you must come here, right? Now, you can have a subpoena is effectively a summons where you don't have to yourself appear in person. You can say on it, you must produce this document. This is what Fauci was doing to, this is what Rand Paul was doing to Fauci. This is what Rand Paul and the Senate do. They're like, Fauci, you've got to compel this document. Are you going to cooperate with us? And then he says, yeah. And they say, well, you said that 6 months ago, but you haven't produced it yet. Are you going to produce it or not? And then, he's compelling information. Well, the thing is, in a legal court case, in a civil court or criminal court, you can compel the judge, right? If any of the lawyers want certain evidence, they ask the judge to issue to sign the subpoena or warrant or whatever, and that compels you must produce these documents. So it could be a lab, or it could be someone who's got documents. They have to give a copy of it, or send it in as an exhibit, and then it will be returned to them, or the police are just sent around to get it. And this fact of the police getting the information and taking it to the court, right? Now, this is the thing. It's an information can be in any form. It can be like on a phone. This is when the police have been taking all these computers off all these journalists, right? You're compelling the information, but who are you compelling it to? Well, you're compelling it to the court, to be given to the court or provided to the court. The police, give it to the CPS, and it gets to be put in front of a jury, a panel of people, right? Now, the thing with the petition is that you're trying to get people to sign it, members of the public, witnesses, like, obviously kind of like jurors, to look at it and sign it. And if they can't see it, they can't read the complaint and they can't sign it and support it, right? Now, this is the thing. Is there anything like that in the other courts that use warrant subpoenas to compel information or persons, right? Well, yes, because you've got a witness appeal, and you put a witness appeal in a newspaper. The police or Crown prosecution or court can put a witness appeal in a newspaper and say, have you seen this person to people? Now, what if the newspaper say, we won't do it? Well, that's where I'm saying this basis comes in for that, because that it's for a legal case, and it needs to be seen by not just a jury, but the entire public needs to see it, not a jury. So they're actually compelling the newspaper to publish it. It's an order, but the government can make an order in law that newspapers must be published in at least one newspaper for roadworks. Now, the standing order, and this is when you get your standing orders, and when you get your resolutions of Parliament and things like that. Like the council makes an order for a road traffic regulation order. You got 3 judges in the council, right? 3 judges in the council, your cabinet. They're not called justices of the peace anymore, but they effectively are, or were meant to be. Your cabinet in the council makes an order, slams a hammer down. It's a court, and the councillors are your jurors, right? And they vote on it, right? To make the order. We're now ordering that all traffic on this street will now be one way. It's a one-way street. So that is the council are making an order, a road traffic regulation order. It's not a bill. It's not a bill, right? That all cars will drive this way down this road because it's now been a one-way street. So that's compelling everyone to drive in one direction down that road. If they contravene it, it's an offence, right? That is the local council chamber making an order, not an act of law or a bill, right? Now, this is the thing. This is effectively what the court's doing when they're doing press bans, right? Effectively, that's what they're doing when they ban the press, right? But they can, if you're compelling the newspaper, what you're doing with a witness appeal is you're making an order. Like, all the cars will drive down this road in this direction, right? You make an order that, or instead of like bring us that paperwork, that document, because the jurors will see it. You're saying the document will be put in the newspaper because everyone has to see it to see if they want to sign it. But it's not a criminal case in a court where the Crown Prosecution Service want some more witnesses to be found and come forward to help them give evidence against the criminal, right? But what it is you have got a case with the Parliament of England and you are trying a case before the committee and you want to prove that there's great evidence of public concern. So you want them to make an order to compel the newspaper to publish that. So then you can get the witnesses to come forward and sign it. Now, the Petitions Committee have got their own website where people can go on. But, you might want to, like I say, you might not be on the front page. You might be buried under, like in the local village on the notice board, you might be under about 50 other petitions and people can't see it. You might not get attention. So you have to put a bit of your own money in, but you can do that. You're allowed to do that because it's not a referendum where the government are sending it to everyone, like the public consultation. It's the petition is more like the candidates in the election. The petition is synonymous with your but the thing with it is with the candidates, the government have set up polling stations and arranged it all. So what I meant to say is it's like the referendum, but in order to get the referendum, you got a petition for one. They have elections anyway every year, but the election is organised, and that's why the organising authority is impartial. All of the candidates are themselves trying to get support, but they've got certain rules in place. For the petitions, if you're trying to get, you can get a referendum with a petition, which will be a government-facilitated thing, which will be completely impartial. But with the petitioning, it's not impartial. The government are impartial, but only so much as a judge in court. Your party, like the claimant, in an illegal case, you and your solicitor are desperately trying to get as many witnesses as you can and get as much evidence as you can to prove that you're right. And then people who are opposed to you are trying to prove you're wrong. Parliament aren't really supposed to be opposing you. Like, these rules are kind of like, I think these rules are very obstructive and hindrance. They're not open and fair for anyone to try anything or succeed. Really, what these Petitions Committee rules have become is like, it's almost like the Crown Prosecutor is the judge and he's trying to stop you from proving your case, even though that he's not meant to be bothered either way. But because Labour and Tory are intimately embedded into the government, they cannot be fully impartial. They become like a judge who has almost become... it's like having a jury and they're all Labour. It's a Labour jury, You don't want a Labour jury because, particularly if you're a Tory, the jury are meant to be selected at random and they're meant to be judged on their conscience, right, of everything that's presented, if you can get a chance to present it, right? And that's the thing. The Petitions Committee are trying to stop people, really, from showing their case to the public, and get them to support it and sign it, even if it's the committee that's voting on it, But you can always go to referendum. They're acting like an extremely biased authority, which is infiltrated with opponents. Not you don't want the judge to be your opponent. You want the judge to be a judge, like an umpire in cricket. A referee in football. This is the thing. You don't want the referee in football to be wearing the shirt of your opponent. These rules are written really to try and block, obstruct, defeat, and independent persons from succeeding through government, because they've been written by political parties, political party bias, which want to beat and defeat you, right? And not have a fair judge. That's the problem. And okay, they've got the website, fair enough, and they've provided the facilitation for it, although it might not be 100% fair, and they're blocking a lot of things out. But it's up to you to... There's no spending cap on, because there's no rules like in the election, because if you do succeed and get the referendum, then they will go out of their way and everyone will be asked, and then they will be actually asking every single person if they want to support it or not. But it's you've got to prove public concern in the same way like a police officer's got to prove that someone's a criminal. You go out and get fingerprints and so forth and so forth. Or if you got a civil case against an environmental polluter, you've got to go get the evidence, and the judge is impartial. But then you might think, well, you've got some cases that the Attorney General's bringing on behalf of the government and so forth. True, but, this is the thing. It is up to... The person who's bringing the petition is trying to prove their case, right? It's up to them to get their evidence. All the signatures are the evidence. So, you are expected to share it and go out of your way to prove the cause and also the writ as well. Not that they're letting you write much on it, but your complaint. So you need to use the newspapers for that, and it's you're on the same. The putting in the newspapers part. I mean, you could put witness appeal on the court, on the door of the court or in the reception of the court, but the only people who are going to see it are people who are going to the court. You can put it in the village notice board. The ironic thing about the village notice board is that, it's like, if it's a corporation, a town, and it's run by a mayor, and the mayor is a justice of the peace, then, when you put it on the village notice board, you clearly got the right to do it if it's a petition to the king, just like with the Royal Mail and so forth, as was supposed to have been. But with the private companies and using their businesses and facilities, there's something in the right to petition that I think compels in law, and the freedom of speech for matters to do with Parliament. In fact, you've got freedom of speech in matters for Parliament, whether you're in or out of Parliament. So maybe that gives you the right of freedom of speech for the newspaper. Maybe that is like the American, freedom of the press, basically. But it's freedom to speak. It's not worded freedom of press, but it's freedom to talk and speak and communicate at least. And you have got a right to petition, and no one can stop you from doing it. And if that's what you're doing in the newspaper, it says that you've got a right to do it. Like I said, no one's liable to legal action. But what if the newspaper just doesn't want to? That's the thing. But they're claiming they're providing advertising for all, It's going to be their business. They're meant to be proving advertising for all people. So, I still think that there's an order that you can have for compelling witnesses, because Parliament is a court and the people who are signing it really are witness. So I think the subpoena powers can be used to compel a witness statement, a witness appeal. Sorry, even not statement, a witness appeal in the newspaper, because it's almost like an order. Like a local council can make an order for everyone to drive down the street one way. So courts can't just go around ordering everyone to do everything, but I suppose this is when you get into injunctions and so forth. But they're using these injunctions now from courts that aren't Parliament, that are interfering with Parliament cases, and no one's questioning it. But Parliament won't use their authority to help us enforce our material online, And even if they publish it on their website and they've approved it, that they're not even just offering it. Maybe some people, maybe other people have been making more effort than me, some university students. Maybe people have been going and speaking to the Clerk of Parliament, and depends, not all people are in London. London's very busy and expensive now. Depends what emails people talk. But I've talked about some of these things before in emails, and they don't seem that interested. But on there, it's always saying, see the Clerk of Parliament. If you're doing it the proper, correct way or whatever. I don't know how many people have ever got a certificate from the Speaker since, the 1800s, at least in these modern times, or not, or knows that legislation. But the Petitions Committee are using summons themselves, and They are requesting certain documents and paperwork, and they're definitely taking things down. And they've got this whole thing where they're getting to the 77th Brigade to start taking things down, and the Americans are as well, but they're not putting things up. And this is the thing, when we've got all these rules which are reducing the whole capacity of it, they really don't want independent people to succeed, I don't think. And they're really undermining how much writing you can put for your complaint, and how descriptive and accurate you can be in it. When you couldn't be more serious and important and high up. This is more serious than High Court. This is more serious than, we're talking like 100,000 signatures is a hell of a lot of people to sign something that is heavily restricted on words. We've got £135,000 cases in the High Court with 8 barristers and 9 bundles of evidence. But yet Parliament pulled it through petitioning or remonstrations against Stonehenge Tunnel. Now, if you've only got 2 paragraphs and hardly even 100 words to try and convince 100,000 people to sign something which is, priceless in money, and you can't get anywhere close to the amount of evidence of 8 bundles of work, your 100,000 signatures clearly is equal, or if not more, than £100,000 worth of money. It's a hell of a lot of evidence of public concern, priceless evidence of public concern if they all sign it. How are you restricted to so few words and writing when it's extremely, it's important enough for the lawyers, if they're going to do it through a different court, which is lower, that they want £135,000 to make a case. And they've spent that much time on it that they've collected 8 or 9 bundles of academic evidence. You've collected, if you did it on paper, you'd have 8 or 9 bundles of freaking signatures in a box. Those boxes they go to number 10 with are 8 or 9 bundles worth of signatures. But they're just like, we consent, we support. They're not actually any facts. It would be all right if every one of them had a statement and some evidence on it. That would be something for the Petitions Committee to look at. It is a process which has been heavily undermined and played down of how serious and important it is. When people are spending a hell of a lot of time walking around, sharing things and doing other stuff like the Stop Euless campaign, and having to go to the streets and try and publicise it and advertise it, supposedly in the privileges, maybe they could be putting more newspaper adverts with the money or more flyers or whatever. This is the thing. What is the most effective way of doing it? There's all these caps. Messenger has got caps and limits on it. Email has got caps and limits on it. But they're meant to be taking priority over from Royal Mail, which you had a right to do it. Especially to buy stamps, but but then you get into fundraising, raising money. Are people going to also give you money as well to help you succeed if they support the cause? If you do get a referendum, then you won't need to put any money into it because all the signatures afforded you a referendum. The government will be promoting it and letting everyone know that they can sign it and to turn up at the polling stations, right, and distribute material. So it's going to be sponsored by the government and paid for with impartiality. And there's not allowed to be any influence one way or the other from the government. But until then, you have to pay for it yourself, and you've got a right to. And if the newspapers are blocking you can't do that. And like I say, if they've got a public notice board, and if they're offering, advertising services, a lot of them used to offer a free advert. If it was for non-profit, which is what it isn't for a profit, and supposedly if they've got a notice board, it's not meant to have any partiality or whatever. You see, if the newspapers started saying, we're only going to advertise businesses that are BlackRock Vanguard, or if we're only going to advertise businesses that are, Chinese, or if we're only going to advertise businesses that are, plumbing, and not advertise any businesses which are, selling kettles or kitchen things, and everyone would complain and kick off that that they'd been discriminatory about what businesses can allow to advertise in there, and then they get a lot of hassle for it. But the only thing usually with these type of things is legal, but they always give legal excuses. But for this, there is no legal excuse because you can't have a legal excuse, right? It's really a political excuse disguised as a legal excuse. There are lots of legal things in the newspaper, like for defamation and this and this and that, and copyright, and that's why they have night lawyers, so they can't be sued and so forth. But not for this is the category that's exempt. That goes for normal advertisers and other companies and businesses. This is the thing with that, like McDonald's now, they're starting to do, like, a lot of these companies are starting to do really annoying adverts which are annoying, and you're getting into medical rights then when you're starting to. That's not defamation or copyright, but it's like, if it's upsetting you or causing you harm and you've got evidence to show that, then we're getting into that kind of arena now with a lot of these developers just swapping and changing things on your phone, or forcing adverts on people when they don't want them, like by force, forcing you to consent to their policies, consent, submit, agree, and things like that. It's getting worse now than it's ever been. But for petitions, there's no liability for the newspaper or the advertisers, so there's no reason to turn it down. I do think that Parliament can get an order to compel them to publish it, and if not, I mean, they could maybe the Gazette is a government newspaper. Possibly could even make them put it in the Gazette. But if you're having trouble sharing it, and if Parliament wouldn't put it on their site, it's like they're trying to kind of reject it anyway. But on the grounds of these reasons, aren't even proper reasons. Now, how can you take Parliament petitions committee to court if they're using privileges? You can't. So how can an injunction affect petitioning? And then when you're going around the streets, you're not meant to be arrestable. They can't stop you going around in the streets. And remember, this is another thing. In civil suits, when you were going about, people could have you arrested for if you owed them money, right? But supposedly not if you were doing this petitioning, because you were in your privileges, almost like peer servants were in the privileges. So you wouldn't if you owed the newspaper some money, you probably might have been able to get out of being arrested by the newspaper guy. If you owed him money, a little bit like the servants got out of being arrested if they owed someone money. So the newspaper guy, you would have a certain protection from him from being arrested from civil matters. Actually, funnily enough, but I won't mind, but the Parliament are giving covert, undercover orders for people to not share certain things, but they're not doing it the other way around. When it does exist, and they do and can use it for themselves, and the awkward thing is that if Parliament aren't going to publish it on their website, they're going to be reluctant to give you a subpoena or a warrant or order to compel the newspaper to publish it, or the platforms, which is very, very unfair then, because at least you've got change.org and 38 Degrees if you don't get it on Parliament website, and people still turn up at number 10 with it, and they still hand it in, right? It's a lot less... people still see it and it still gets shared, but Parliament didn't want it on their website to be awkward. It's getting to a stage. If you can't take them to court and they're saying that you can't prosecute them, right? You can't take the petitions committee to court and criminally prosecute them or civilly prosecute them, right? Maybe you can take civil action against them, not criminal, in between the sessions, or injunction. Maybe we can actually, and challenge them on their rules. But they say that Parliament is their own judge when it comes to privileges, right? And if Parliament Petitions Committee is only operational when Parliament's active, then it's only going to matter when it's active. So that's not going to be any use unless you bring it in between the sessions and then you get it sorted out for when they next have a Parliament. But then that's yes, so you might actually be able to bring a civil suit against Parliament in between sessions, but the only problem with that is it's actually no good if you're being further hindered, obstructed and slowed down, that you're going to have to wait a whole 6 months or a year till the next Parliament, and if you manage to sort it out in between those sessions, you want it to be sorted out while it's running, and get it running, and you won't be able to get it running if they're protected by privilege and can be their own judges. And I think this is what they're really doing with these rules here that we're even looking at. They're saying we're our own judges for everything, even policy, and you can't do anything about it. But this is why when they make something law, they're meant to put it through Parliament. And when they put something through the committee or have a resolution or standing order, it's going to be official. And the things that they are... What the decisions when the committee use their own judicial power as a chairman and as a committee, right, is the work going through that we bring there, right? They're meant to be hearing the cases that we put to them and that we collect the signatures on. That's the bread and butter running through it, like, criminal cases in a court. But yet, them just sitting there and coming up with all these rules, twiddling their thumbs and coming up with all these rules, all these things that we can't do, that's not... I didn't submit that, did I? I didn't submit it. You didn't submit it. It's not our casework, and it's not standing orders, and it's not resolutions, and it's not putting a bill through. So what exactly was it? It seems to be them not doing the work that we've submitted to them, but instead thinking that they've got some kind of imaginary, allocated time to come up with fake rules, which is separate work from, doing the paperwork of what's run through them, or meeting to do standing orders, or meeting to do resolutions, or meeting to put bills through, vote bills through Parliament, then they've conjured this other thing up, which is making up fake and false rules, which try to obstruct people from putting work through, when they've already got the rules, It's like we've got extra rules now, which is almost as bad as, this is complete and total, like YouTube policy. Well, you've got law, Why do you need a policy when you've got law? The policies are meant to reflect the law. Oh, we've got these employment laws. The government made these employment laws, so we'll have to make a policy up, that, if you don't turn up so many days a week, we can sack you because that's what it says in the law, but they're going beyond law. They're saying, it's not there to remind you what the law is and say, oh, by the way, in this establishment, no fighting, no shouting. That's understandable because they're all illegal things. But it's almost getting to the fact of state when you've got these Facebook groups and it's like, this is a tennis group. We only talk about tennis in this tennis group. And if you don't talk about tennis, then you're not in tennis group. It's gone beyond the joke. It's like when you go play squash with someone, when two friends go play squash, they socialise. They talk about all manner of things, what they've been up to in the week or whatever. They're free to have a discussion, right? And they're playing squash against each other, and they might say, oh, that was a good shot or whatever, or that was a difficult shot. But they're free to talk. You play tennis with someone that you're comfortable with, who you get along with. Maybe there might be some people who don't talk about anything except, what they're actually doing. But, you play squash with the squash partner who is suitable for you. Once you get to this thing where, I'm in the red room now, we're going to talk about red in the red room. There's a red chair, there's a red painting, there's a red lampshade, and there's a red guy just walked through the door, right? He's called Red. If you get to that stage, it's getting what Zuckerberg's created is obsessiveness and antisocialness in a way. It's kind of worse than paranoia. It's almost like, this is the do this room and this is the do that room, and it's there's a lack of fluidity to it. There's a lack of spontaneity to it. There's a lack of creativity and freedom to it. I mean, it's going to be annoying if you're in, you're going skiing and, everyone drives through with tractors, but sometimes tractors drive across a ski track, if there's a farmer, happens to be near there, you got to apply initiative and common sense, and some of these group admins get very authoritarian. This is what's happened to these petition committee people. It's all part of what's happening. You got to call them out on it, So we're on political party material. It contains political party material. Well, the thing is, a political party, you're voting for the person, and the whole thing about being selfless on the council and having a selfless policy it throws the old political parties into question anyway. And then when you think the councillors are kind of really Durats, but just there's a lot of them because there's a lot more wards than there used to be, so they have more than 6, 9 or 12 or whatever. It's almost like a grand jury, and then you think, well, but the jury it's a Labour jury. Isn't that a bit biased? But they got rid of Labour. They got rid of Labour juries because then the bosses wouldn't be able to build factories everywhere because the workers wouldn't let them. So we can't have Labour juries. It's the whole political party system's under question when it comes to political parties. But if you want to say, it contains political party material, the political parties are trying to prove a case, but they're trying to prove a case in a official competition, which is facilitated and funded by the government. The government advertise that there's a competition on, and when to vote, and it's also put onto TV, and everyone knows that it's there. But they do a certain amount of promoting the event, and that there will be an event, and everyone should turn up, and there's going to be some choices to make, and everyone should go and make those choices. The difference with the petition committee is that they're not telling everyone that you've got a petition, and if they want to sign it, you can. Everyone knows there's a petition. It would be more like voting and polling station if they heavily promoted the petitions committee itself and petitions, and did a lot of promo for it with complete impartiality, and let people know that it's there all the time, and had some kind of alphabetical library shelf system which didn't prioritise particular petitions that were more populist model, were the ones that were at the front, which had more signatures, and they were all actually searchable under category. You know, like if you do it in alphabetical order, like agriculture, food, cooking, taxation, things like that. If it was A to Z and then some miscellaneous, I suppose, that would be something. And then if you just, you clicked on it and then it didn't particularly give any advantage to any particular petition, that would be a lot more like an election. And if they publicised that the website was there and promoted it quite a lot, and so forth. But even then, you still need to, you're still trying to get attention to your case and prove your particular case. And the government aren't meant to intervene. It really is kind of like court. And with court, it's like you're kind of by yourself, it's up to you. And I think with the political parties, the thing is with the political parties, right, once they're on the ballot, right, once you're on that ballot, you don't really have to do anything, really. You don't have to do promo. You can just be on there because when people turn up, you're going to be on that paper, right? And they're going to see you on the list, and they can choose you, right? So all of the money spent and the promoting and advertising kind of is extra, and you don't really need to do it. But there's a spending cap on it anyway. Although they're getting £5 million worth of donations, these Tories apparently, and massive donors. But if the election was more like a petition, like they were meant to do in America, apparently you could write down two names, one for the president, one for the vice president. But one of the name was had to be from out of the state, and one had to be from within the state, like her home and away name. But you could write down whatever name you want. It was complete freedom. And that was just completely and purely up to the candidates to promote it. Then it would be all about the spending. Because when you go to the polling station, they don't have the advantage of already being there in front of you. It's like going onto the Petitions Committee website, and there just happens to be a first page of petitions, and there's 20 on the first page, and you see those, and they're getting a bit of free advertising from it, and it's populist. And, there's an advantage there. It's almost like in a library, every author's competing to get you to choose their book. But they happen to have particular ones that are on a display when you walk through, rather than them all being on the shelf, just with the writing down the spine, and you're looking for what topic you want, and when you find one on that topic, then that's it, that the voting's there's not meant to be anything on there, so when you go in there, the system that the government set up, the system that the government have said, there's an election on, we've got all these polling stations, it's on Thursday, we've got to let everyone know to go to the polling station on Wednesday to go vote. and you get a thing through your letterbox to tell you that, you know, everyone's going to go vote. And they've promoted the event, the system, but none of the candidates, right? Now, if you turn up at the polling station and there's a blank sheet of paper, then that's completely and totally unbiased, you know. But when you get these, well, there's so many candidates on there, they've managed to get on there, and they've almost, you know, it's who you're going to choose other than the people who are written down on there. The opposite in America was that there wasn't any names on there, I don't think, and I think that when they tried to do it, so it comes from you, right? You can write down what you want, and it's up to leading up to the election, right? It's purely up to the candidates or the people who want people to vote for them to use money to try and get people to write their name down. And it could be anyone, you know, and then it's every man for himself, you know. It's kind of like, you know, how much money you've got to spend on it. But then you're still going to get people who have got a hell of a lot of money, like Donald Trump or, you know, Bill Gates or whatever, doing a lot more, can afford a lot more adverts than everyone else, unless you had a spending cap, and then everyone could, or if everyone got one advert in the newspaper, or if everyone got one slot on the radio show, or whatever, it's kind of the equivalent of being on that ballot paper, but prior to going into the polling station, you get to hear who is interested in doing it, or who might want to do it, or you just can put who you think should do it. I don't know who would ever turn up and vote and write down anything other than whoever the best, you know, the best idea they can think of that should be doing it. Like, for example, I don't know, like, you know, if you thought it was Neil Oliver, I'm not saying that you should vote for Neil Oliver or that I would, but this is an example, you know, or whether it was Russell Brand or whether it's Tucker Carlson but these people, again, are just other people who manage to be able to, they've got a platform, they've got attention. It could be your doctor, you know. You go to the doctor, your own doctor that might, you know, he'd make a good president, you know, or even one of your friends. But at the end of the day, you're free to write down what you want, you know. It's almost like the conscience of a jury, you know. And I actually think that model's the best model. Now, do those candidates who might be presenting themselves in the election, do they have a right? Do they have a right to the press? Well, I think that's why they've got freedom of the press in America, you know, because you can't stop them. You're not allowed to obstruct them or stop them. I think that's why it's in the First Amendment, that they're allowed to be. I think the freedom of the press is that I don't think you can stop someone from putting an advert in a newspaper, particularly if it's for an election. Not allowed. I think that's what the American Constitution is, which is an extension of free speech in or out of Parliament. You know, and that comes from legislation, an act, which is, you know, like it's an order for the federal order, isn't it? You know. So, now, after all that being said, it contains a party political material, right? So that would be, if you on your petition put something to do with a political party that favours or opposes it, then it's going to end up potentially getting into Hansard if they write it out, and then so that's probably why. So that is one of the rules that maybe could have some substance to it. But saying that, I mean, it's the right of the subjects, particularly for petitioning, and it isn't an election. When there is an election right, you're not allowed to influence, and the government aren't allowed to. But if there isn't an election on, if there is not an election or a by-election on, I don't know. But maybe that could be, if this now is probably the first example out of all these where I'm thinking, well, maybe you've got a right to petition. It wouldn't actually matter too much, you know, back in the 1600s, you know, when petitions weren't getting shared, published wider in the newspaper, or if there's only one signature on it. But if it did get read out and put in Hansard and actioned, then it would get mentioned. So that maybe that is a problem on there. But saying that, what about that petition for the guy who got removed? I've got there's an example of this. There's that guy who Parliament said that he shouldn't be elected as MP for whatever reason, and they said that the guy who came second should get the position, and that is they had a debate of it in Parliament, and that's in the sessions, in the records, and a petition. There were a few petitions going backwards and forwards about it. And he didn't get elected, and he wasn't even a political party. As an independent guy, right? Independent guy who's even got the backing of a party. So you must have been able to do it then, and they had Hansard, but it was before they were starting to do mass publishing in the 1800s, and they protected themselves from defamation. It might only be the political party who tries to sue for defamation, but they won't be able to if a speaker hands it out. So what I'm thinking is the political parties might not like that. And then if they're controlling government, they might try and put a stop to it because they don't want their own party to get, smashed in by these independent petitioners. So that itself could or would be illegal. Now, the evidence we've got on this from 1600s is definitely that those subjects and matters can be discussed because they have been. And actually, I think that particular little petition escapade had maybe 2 or 3 petitions knocking around about it. It's actually that's one of the that is one of the widely researched historical events. That particular MP who there were a lot of issues around it, but that did get into session books and Hansard and petitions, so can do it. But big parties aren't going to like it, but I don't think they can get defamed, really. But really, it's only a little bit like when Hansard published about that guy and he didn't like it, so the political party didn't like it. Now, is government affecting a party or not? Well, the thing is, I think I've got my head around this one now. It depends who brings a petition, because if you're an independent person who isn't party affiliated, you got a right of any subject. And if you have got a grievance or a concern about political party, then you actually do have the right to petition about it. Now, you brought it, the government didn't bring that, and the government are meant to be like impartial and a judge. So it's like the whole court thing again. They can't say what cases can and can't come into court. They're just meant to be impartial and judge the case, right? And if they do publish it, they're only publishing it because someone brought it and petitioned it, and they collected the signatures and it got debated. It wasn't actually the government themselves who said, okay, we're going to publicise this party or that party. And this is the thing with local councils. Local councils are themselves, they're pushing their own policies and publicising their own policies, and now they're even putting radio shows on which are pro-regeneration or this and that, which is that's really illegal. But no one's saying stop them from doing it. But the government is saying, no, we don't want any petitions about political parties. But they might as well say, well, we don't want any radio shows about regeneration. This is the thing. Labour Party pro regeneration. So I don't think Parliament would be in breach of their privilege if an independent person got a petition through and it got debated, if it was a legitimate matter. And I don't think the political parties could sue. Is it influencing it depends who brings it and what circumstances it's in. If it was like the opposing party and they were having a party warfare through petitions, then fair enough. But this is why political parties aren't a good idea anyway, and why, particularly when there were less political party control and dominance, and when it was like more independent petitioners, then you didn't have that problem because there weren't political parties. you didn't have a political party. So how can you wouldn't have this rule here to try and make out that it's no good? And that petitioner, apparently Parliament said he broke the rule. I mean, why did Parliament intervene in his election? Someone's got to judge the election. You call out an election, you get an election petition. It's a particular. What is an election? Isn't an election petition, for or against one political party? Is an election petition, is the Attorney General favouring one party, when they count the things? Well, they just counted them and it turned out that, someone called it out. Is the person who's calling out one party or other for breaking the rules in the Representation of the People Act pro or against the party? Police aren't meant to mess around with the materials. There are certain laws and regulations. The thing is, if it's a law that's been broken, right, and it's a political party and you've got a grievance over it, well, I think the point is they broke the law, or they didn't do something right. So it's almost kind of like, if there's no cause for concern, then fair enough. It's almost like, if no one robbed the bank, whatever. But if someone did, they did. It's. But then you're getting into this whole thing, are people just doing fake incidents and grievances for the publicity? Which, that's the question with the whole country, what we've got at the moment with the newspapers and these electric vehicles blowing up and all manner of things happening. Are a lot of them doing all those things, for the extra publicity, for political? Are the newspapers running certain stories and controlling them for a political response and to get people to support the parties, like the Democrats, Trump and Kamala Harris, which we know they are. So, it's political parties make the whole thing very questionable. Some of it's got to be illegal, like, that selflessness policy. How is that compatible with having a political party control of the council? It can't be. We'll move on now from this contains political party material. Now it says it's nonsense or a joke. Right, so they've got a rule that says it's nonsense or a joke. Right, well, the obvious one for that is a Monster Raving Loony Party. So the Monster Raving Loony Party, is it a serious party or are they just doing it for fun or a joke? Right? Well, it's an official party. And they actually register for elections and turn up, and they're on the ballot, and you can vote for them, right? It is a Monster Raving Loony Party, and that Hope guy's been elected before. They're actually a registered political party, and they're in many local elections, although very few, if not any at all, government election, central government. But they enter a lot of local by-elections, and whether they do it for fun or not, or really try to get elected. I think they've got some councillors, because apparently 2 councillors in Durham, or somewhere around Northallerton or Durham, converted to Monster Raving Loony Party. So I think they actually got them by joining the party after they've been elected. Whether they still are or not, I don't know. But some of the they've got a manifesto. And they've actually got policies, and some of those are silly, questionable, or impossible, like, legalise unicorns. Now, apparently, lying or fraud is a breach of privilege, right? So, some of those can't possibly be true or correct. So, they've got to be fraudulent or, they've got to be... a forgery. It's forged. It's not actually real or possible. So therefore, it's a lie. It's not true. Like, unicorns don't exist. So some of those policies have to be a breach of privilege, or at least possibly. But none of them has been elected to Parliament. I don't know what we can say about that. They entertain it, they let them do it, and they're actually in the election, but they've got all the, so if they're letting those people in those elections running on those manifestos and policies, then you must be able to petition them to Parliament, right? But they're saying that they're not here. They're claiming that you can't run it if it's nonsense or a joke. But all their manifestos are nonsense or a joke. So, you know, it's going to be free right. Does that symbolise the free right of the subjects, even if it is nonsense or a joke? You know, the Monster-Raving Loony Party at least proves that if they've got a manifesto and policies that are nonsense or a joke, then you must be allowed to petition it, you know. But maybe if it is actually proved to be untrue and not real, maybe you're not covered by privileges, which is quite an interesting position to be in if you're doing a petition, you know. But are you trying to prove that it's true or real, you know? If you're trying to prove that it's true or real, then at least you're giving it a try. If it is an advert, spam, or promotes a specific product or service. Well, this one is actually one that I really disagree with, and this is one that they need to take into court over. If you could take them to court, the Petitions Committee needs to be either challenged on this or taken to court, or the Attorney General or something, right? Not allowed if it's an advert, spam, a promotion, or specific product or service. Right. What the mistake is, they haven't added the word commercial, right? If it's a commercial advert, right, or promotes a commercial product enterprise in business for profit, right, it should say that. They've been very vague with this, because how it's written now cannot be legal, because the government's own website itself actually is advertising them, and it is an advert and it is a promotion, right? But not supposedly meant to be in favour of one party or the other. They're meant to be hosting all and every of them supposedly equally. But that populist aspect of it, populism, does add favouritism to it. Then again, you could say that's the fact when they're choosing which ones they're going to debate, even though everyone's got the signatures, you know. That's got to be some kind of bias. Now, it says that you can't run it if it's an advert. Now, in the government's own legislation, in the Town and Country Control of Advertisements Planning, in Schedule 1, you've got Class E and F. And F is actually for things that you're running through Parliament that actually operate on standing orders, which this committee does operate on standing orders, and you're using the right to petition enactment, using enactment as well, right? So, according to the Act, something running for Parliament on standing orders, using an enactment of law, is an advertisement in law. It's legally defined as an advert. And further to the Act, the 1990 Act, which is also in the guidebook to it as well, they combine the 1990 and 2007 together. The definition of advertisements, is a representation, which is legal representation. So it is legally defined as an advertisement. So you can't say that it can't be an advertisement, because in law, a legal representation, when it's being shown or displayed to the public in any form or manner, is an advertisement. So this is actually illegal. Then that's actually breach of privileges. By publishing these rules is a breach of privilege and forgery. They're forged rules. So the Petitions Committee is breaching privileges itself. So they can really be prosecuted. They can be prosecuted through the courts, but apparently they get to choose, you know, themselves decide if it is a breach or not. You know, they get to be ones who decide, almost like Boris Johnson and Hanningfield in a way, but, you know, like they were MPs who usually just stand down. But we've already had the Petitions Committee and an entire government stand down, which is how Starmer got in there, you know, and called the general election. But this is criminal, illegal. probably could take them to civil court during intervals of sessions. But it makes you wonder what Tommy Robinson's doing in prison at the moment, with that injunction, if he was petitioning in his video thing, and everyone else who's had an injunction who was properly doing it. Because it can't just be us or them, it has to be us and them, or none of us, with privileges. So this is illegal. It is an advertisement. It is an advertisement, and it is promoting a service, because the Petitions Committee itself is a service. So it is an advert in law, and that's defined. So they're actually in breach of these rules are a breach of the privileges of Parliament. And that's probably the most important one of them all. And the fact that they're not actually helping us, they're giving directions to share it. They're operating on standing orders, and they're giving some instructions and directions to share, but they're not giving us any support or offering any enforcement in that sharing. But they're enforcing it when they don't want us to have things up, and they're wanting to take it down, which is ironic, saying that the policy is illegal. It's not even a policy, because it's not even standing orders, is it? We're going to move on to the next one now. It's a Freedom of Information request. Well, they've got a separate. You can make Freedom of Information requests to them by email anyway. Why do people need to sign a Freedom of Information request? Well, it would. Sometimes they charge you some money for doing it. Maybe if a lot of people wanted it, it would justify not charging you, or if it was important. A lot of times they refuse a Freedom of Information request. Remember, the signatures are evidence of public concern, which compels them, right, to vote in your favour, or to vote judgment in your favour, because you've got great evidence, like in a court, right? Now, the thing with the Freedom of Information request is, I actually tried to get the DVLA when I was investigating the DVLA for the driving licenses. When I got the whole thing over the weight of the 3.5 ton van not being a goods vehicle, and therefore it should be the same speed limit on single and dual carriageways as a car, not a vehicle over 7.5 over 3.5 tons, like a 7.5 ton wagon. And David Cameron cheated and snuck the law and updated the whole internet and everything without telling everyone, and tried to make it as believed that it'd always been a different speed limit, when it says on this driving license from 1993 that the government issued that it's not a goods vehicle. And the police say that, well, the police don't go by the weight. They say that it's defined and labelled a goods vehicle, so that's what makes it, brings the speed down. But that license says that if it's under 3.5 ton, it is not a goods vehicle, right? And there's various things in. It is quite a mysterious thing, but there are acts of law which show that under 3.5 tons isn't classed as a goods vehicle. In various examples. So what I was trying to do with the DVLA is I was trying to get I wanted like to see every single driving license that has ever been made and issued. Now, if you go back, I mean, these driving licenses, from the 1970s to 1994, they used to last for. I think they kept the same ones running for a few years, maybe 2 or 3 years before they changed them. But if you go back too far, well, if you go back to like the 60s, they were using these little tiny books which were never really around. When I'd never seen them. I think they were just a little bit before my time. I think my granddad had one, but they're just like a little book, and you never really used to get banned for a long time. You only used to get banned for like a week or a month. They didn't do like year bans or anything. It was just like very, very short periods of time, small fines. But definitely through the 1970s, they upped their ante to start doing this whole disqualification thing with these point systems, which I think is illegal, right? I think it started brooding around this 1963 or 73. I've got, it starts, I think there's something definitely coming on with that, taking the peerage privileges away so they can get all the members of the House of Lords with speeding tickets rather than using their privilege against it. But that's before speed cameras. Speed cameras didn't turn up till the 1990s, but there was something going on with your 1948 and 73, they were messing with privilege, but they still had those little books then, and they didn't have like long bans. Privilege would have been an obstruction to them being able to punish members of the House of Commons and Lords, I would have thought. But you had special reasons anyway, though. But you had to. I think you had to be dangerous driving twice to be disqualified anyway. Not on the first offence. But it would have protected them from prison, though, if they'd been dangerous driving. It would have protected them from getting arrested or going to prison. So driving might have played a role in when they did it in 1948, but then 1967, sorry, 1948 and 1967. But that's way before there were speed cameras and so forth. But they definitely went to town after the 1990s, and that Robin Hood Prince of Thieves come out, and this is my river, anyone who wishes to cross it must pay a tax. And then that was almost like the introduction of it all. So it's definitely a modern thing. But remember, they had all this. They hadn't got rid of all the differentiation between the felony and the whole thing to do with the assizes didn't go till 1970s, early 70s. It's definitely in the modern system anyway, the whole thing for that. But anyway, I wanted to try and get back to the point. I wanted the driving license specimens, the copies. I wanted to see every single paper driving license that had ever been made by the government and issued, because although I don't think there were that many paper ones, because you don't go back too far and then they become these little books quite quickly. But I think there's that 1991 one, which was 1991 to 1994, and then you get into sort of like after that, then there's one that I had when I first started driving. I don't think there were that many of them. Because before 1991, there'll be one through the 1980s, and then I think 70s, but there might be maybe 2 or 3 paper ones, and they will have the information and evidence on them that tells you about that weight of the vehicle, and they would not give me them. And I know that I'm absolutely right about it, and this is a dispute I had with that chief executive woman at DVLA at the time, around 2013 to 2015. She would not say that I was wrong. She refused to say that I was wrong, and she knew that I was right. But nothing got done about it when it was a major thing. And Cameron had done a little swindle. He'd just done a sneak, like, let's change all the colleges in England quietly to academies, let's see if, anyone will notice, and the next thing, this is weird. All these colleges have changed the name to academy. Like, who slipped that one in, the back pocket, Cameron just did it like that. This like slimed it in, like slithered it in. And he didn't think that anyone would notice when it was completely, totally criminal, This is why I don't like these people. Same with COVID, didn't it, But anyway, the DVLA would not give me the specimens. They didn't want me to have them just because, other reasons, like they didn't want me to copy them and other people to get hold of the files, or, they just didn't want me to possess them. When it's a government document, you've got the right to information of any government document that's ever been made or issued, right? Should be in National Archives. And licenses and certificates and things like that, people are entitled to have them, but they do specimens. A specimen is something where it usually is made out to a person, but it's got like, a specimen written across it. So if you copy it, it's not exactly the same, or they have it made out to an imaginary person who doesn't exist, right? They don't want you to get the blank ones so that, you don't go on Photoshop and change it and pretend, but they're all documents, you don't even use them anymore, so why does it matter? It's historic, It's a historic document now, it's not even in use or circulation, so there's no reason for them to not want to give me it. So, I mean, if you're doing a petition which you want to showeth the government that the speed limit on the vans is this and that, and that there's some error, even if you're not accusing Cameron of wrongdoing, even if you're not accusing the DVLA of wrongdoing, even if you're just saying, there's something strange is going on here, this should be like this or that, and I'd like that affirmed or confirmed or corrected, or, you can quite easily say, without breaking these very tenuous and just ridiculous rules, that I've got this driving license, it's a government one, it says that vans are not goods vehicles if they're under 3.5 tons, therefore the speed limit cannot be this on dual carriageway, but people have been done by that on them, and can we have the fines back, please? Someone must have made an error. Oh, it must have been an accident. It wasn't it's not a wrongdoing then. I'll just say that it was, someone made a very silly mistake, a very stupid mistake, he wasn't wrongdoing, it was just an accident, There's been an accident. They've accidentally been prosecuting, vans as if they're cars, as if they're vans. But in order to show us that, I need the actual driving licenses. I want to submit. I want to. But and in order for me to be, in order for me to be convinced and know that I'm right, to try it, I need to see them. But they didn't even want to give me them to see them, even if I don't annex them to the petition or link a photograph to the petition. I had a right to know that knowledge in order to write a statement out to say that, I now give testimony in my statement because I've seen it and I'm sure of them in them, right? Which is like what you're meant to do. But up here in their other clauses, they've got like, in their other clauses up here, yeah, what they've got is they've got like, you're not allowed to submit any evidence that hasn't been proved to be correct. Well, that's what you're trying to do. If I write a statement which isn't proved to be correct, they're saying they won't accept it. Well, unless the DVLA send me those driving license specimens and I look at them and inspect them, right, then I can't write the statement down to say, 3 driving licenses issued by this government say that a car is not a goods vehicle and neither is a van if it's under 3.5 tons, right? Right, now I can write that because it's true, it's a fact, because I've got your documents. If the DVLA won't give me them, then I can't follow this other rule up here which says they're claiming that nothing can be submitted unless it's proved. But proved by who? Proved by a court or what? You are trying it, you're proving it, You're hoping that, you believe it to be true. That's the point, or why you'd be submitting it if it wasn't true. You believe it's true, and that's what the oath is. The oath is that you believe it's true and you think it's true, and you're submitting it as evidence. You want it included, or if not in any other form than it translated into a verbal statement and descriptive in as part of your statement, which they're trying to really reduce and take out the amount of words you can say. So freedom of information. Well, the DVLA, what was the point in telling you all that? There's an important point. One of these rules here we've said is it can't be a freedom of information request, but I submitted a freedom of information request for those specimen driving licenses through the 1960s and 70s, the other paper ones, and they wouldn't give me them. Now, how can I make them give me them? Right? Well, if I'm writing them letters and they're ignoring me, and I've submitted complaints forms and they're ignoring me, I need to make them do it. Now, I could go to a criminal court or a civil court and get a judge and a subpoena and compel them to give me them. Right. But I am bringing a legal case to Parliament because it's not a matter that I want to take up in any county of England or at the High Court, because it's a government department, the DVLA, and you petition about government departments who I don't think that they're telling the truth about these driving licenses and what the speed limit is. And they're the ones who apply the points on the licenses when the police do it. And if we knew the police were doing it unlawfully, then they would have to do something about it. And then there's all the courts as well. So I need those driving licenses, and you're getting them through the freedom of information. Now, I could submit a petition to the Petitions Committee saying, I want those driving license specimens, right? What they're effectively saying is, if any other department of the government refuses you information, right, we're not going to allow you to collect signatures from the public to compel us to do it by way of public support, evidence of public concern. The public are commanding or demanding that information, which is like the jury, right? They're trying to get out of being compelled to give information if otherwise they refuse a FOI, right? So it's why have freedom of information requests, if you're not going to comply with them? I think the Judicial Conduct Investigation Office had an argument over it as well to do with parliamentary privilege. Well, it's funny because the Lady Chief Justice surely is under parliamentary privilege herself, but the rest of her office isn't, so it's a bit of a weird situation. Maybe the things that pertain to her and Parliament aren't, and things that just pertain to the courts and that office are, I don't know. But apparently said the office was on the freedom of information. So, yeah, I mean, a freedom of information request, it doesn't need to be a freedom of information request under the Freedom of Information Act, though. A Freedom of Information request under the Freedom of Information Act is done under a particular act. It's not done under the 1688 Bill of Rights right to petition, right? It's almost like the difference between these protests, right? These civil, peaceful protests and using the right to petition, which is parliamentary privilege, and then Extinction Rebellion and wondering why they're getting arrested. That's the difference. It's a Freedom of Information request. Well, it's not the Freedom of Information request if you use the 1688 Bill of Rights, the right to petition, which you can actually ask for evidence or warrant through that, because the whole point and function of the Petitions Committee is to compel evidence and documents. So what you do is, it's not a Freedom of Information request, and you're not using the Freedom of Information Act if you summon up the 1688 Bill of Rights right to petition and say, I petition this committee to use its powers of Standing Orders 145A to compel the following documents from the DVLA. All paper driving licenses from 1960 to 1980, right? And I would like a copy of them. That's actually not a Freedom of Information request, because it has to be through the Freedom of Information Act under that legislation and provisions, and it's not then. What it is actually a right to petition using standing orders of Parliament, summoning paperwork. Why would you want that paperwork? Well, because, for another petition maybe. I kind of want those documents for another petition that I'd like to submit then, therefore, afterwards, using that information, right? That's the way to do it. So, in a way, you can request information. There is a way to request information through Standing Orders of Parliament to summon documents, but it's not the Freedom of Information Act. So you're doing the same thing, but using a different process and different legislation, but it's the same. So that's just misleading. They're trying to make it sound like and seem like you couldn't make use of the Petitions Committee to try and get hold of documents or information when you very much can. And it's a more powerful and potent way than freedom of information. Although freedom of information is meant to be a powerful and potent way, but if they're damn right ignoring you, you need to somehow make them do it. And you can make them do it by getting a large number of signatures behind you of the public and compelling them to do it. You know, so that's that one. And then here we've got it contains swearing or other offensive language. Well, maybe, you know, the etiquette of Parliament, it's not a crime and it's not law and it's not arrestable to swear or whatever, but usually it's the Speaker is displeased with members and sends them out if they don't behave. But that's purely on tradition and custom and etiquette. It's voluntary. It's voluntary. You know, there's actually, you know, usually if you're polite in petitions, a lot of petitions that I've read have actually been actioned, and some people have got success in some of these petitions, even to the Lords as well, if they've used decent language of writ. But we don't know who wrote it. Not everyone could read and write. Ironically, I read one which they really didn't sound happy about and seemed quite angry about when he did use a little bit of. I've never really heard any of them use what you call swearing or bad language, but on one of them, a guy goes, he was saying that this guy came close over to him. He was reciting what happened. He was like giving an account, and he said he was saying that one of the Knights of the Realm, he went over to him and he owed him some money. The knight owed him some money and he wasn't paying it. You know, he was using privilege to protect himself from paying his debts to him, but he came over to him in a threatening manner and spoke threats to him in a menacing and somewhat like, you know, he came close to him and spoke threats in a menacing and intimidating manner, or something kind of like, you know, out of Pirates of the Caribbean or something like that, you know, but maybe held his blade up to his throat and threatened him in a menacing and intimidating manner or something like that. It was almost kind of like something out of Pirates of the Caribbean, but he put it in writing. I thought it was quite poetic, but it's definitely kind of a bit slangish. He wasn't swearing or anything like that, but he was giving an account of someone else acting towards him in a threatening manner, which a lot of them were making complaints like, you know, they've took my money or they stole the things or they owe them money. But on that one, he added a bit of, it was very theatrical and quite menacing, actually. Maybe the Parliament might have thought that he was, you know, threatening them. But I don't think that the person in the Lords was too best pleased with it by what they wrote on the postilles. And some of them have actually got orders written on the actual petition on the postilles, and they're actually, which basically means the petition is, they're actually writing, they're warranting it, that they're giving it warrant by actually writing on it, certifying it, authorising it on the actual thing, on the actual document itself. And some letters were sent out to sheriff officers and put up on the notice board. So, yeah, I mean, fair enough. I mean, you know, if you write the F word or whatever and so forth, I mean, I don't really find a necessity or need to swear in petitions. But the problem is that anything that now could potentially just, you know, be a pain for the government or show that you're not even accusing them of wrongdoing, but, you know, clearly it's evident that even without accusing them of wrongdoing, people can put two and two together and notice that they definitely haven't been doing something right, or You know, it's they don't seem to want anything on there which is challenging or in opposition to political parties, even though Laura Corrigan can challenge them on tampon tax. And the committee itself, the integrity of the committee itself, the main thing that want to be challenged on is these rules, particularly when some of them are just lies and clearly a breach of privilege. But what can you do if you email them and they refuse to acknowledge it and just, ignore you? How can you get it resolved? I mean, what are you going to do? The Parliamentary and Health Service Ombudsman didn't want to get involved with the Petitions Committee before, and I realised that actually it is them, but it's a complaint against the particular minister in that committee who's dealing with it, not the committee as a body, right? And also Privileges Committee as well, really. This entire video, after I finished putting it together, because I've had to record it in separate parts because memory card keeps filling up, it should be sent into the Privileges Committee, and I really don't think they want to sit through it for 3 hours listening to my scrutiny of that committee's conduct and behaviour in writing these rules. But I think that they are a breach of privilege, and I think that they are false. They can't be possible. The majority of these rules are either lies, they defy legislation and law, and they're obstructive, if not illegal, criminal, and that's a parliamentary offence. That's a parliamentary offence. If it's offensive or extreme in its views, that includes petitions that attack, criticise, or negatively focus on an individual or a group of people. Well, what about the Luddites? What about the suffragettes? Because of characteristics such as their age, disability, ethnic origin, gender identity, medical condition. Well, this is ridiculous now, because it's actually trying to make out that it's trying to get into stopping you from really changing certain laws, or saying that some laws are even ridiculous or that we shouldn't have them, or complaining about certain laws. Because really, a petition is a complaint and grievance, but it's saying that you can't have complaints or grievances on these characteristics. Why just those characteristics? Well, this is ridiculous because, funnily enough, right, Keir Starmer has said that he wants to make assisted suicide legal. Legal. He wants to allow it. Well, that is anti-Semitic, and it definitely is harmful to the Jewish religion severely. And then what about those abortion clinics? Well, you say that, you want to do a petition to legalise abortion clinics. Are they going to say that, oh, no, well, it's about, it's about a group of people who are protected class, having an abortion because of their sex or race or gender? But what about prayers? That legislation is actually an attack on Christians, because the Christian law and the confirmation of the charters and Magna Carta say that, the Christian religion cannot be repealed or overridden. And one of the main the book is like God's law. It's used as God's law, is the Bible, and it says, like, let us pray. So if we're to let us pray, they're not letting you pray. Now they might say, well, we can we are letting you pray, but we're just saying you can't pray here or there or there. Well, no, you're not letting us pray there or there or there. It says let us pray. You have to be able to pray. Let us pray. Indefinitely, without any restriction at all. So that's really cutting into the Christian religion, because it's not letting you pray, particularly in places where there are departing spirits and people dying, which is one of the main core requirements for it. If it's not Christmas or a wedding or a someone dying, then what's the point in praying, you know? This is like, I've realised I didn't really know that the Green Party and Ed Davey were right mega woke, but I've just realised that I didn't realise when Kamala Harris are doing all these like ridiculous pronoun stuff, and then, I mean, I thought the Lib Dems were alright, but then when Trump won, not that I'm a great fan of Trump because I prefer F. Kennedy Jr., but when Trump did win, I'm like, well, phew, at least, you know, Biden wasn't. But the viciousness, actually, and the spite and viciousness coming out of, actually, the Lib Dems. I mean, you've got all these rules here that you're not allowed to do this, this, or that. They're coming out with, like, dark stuff, like, oh, today is a dark... Not just like, oh, we're very disappointed. You see, if the Lib Democrats and Ed Davey, the leader of the Lib Dems, were following these rules and guidelines... He would have said, from his political party, right, he would have said that, oh, well, I'm very disappointed in the results of the American election today, right? That's what he would have said. I'm very disappointed with the outcome of the American election today, but instead he didn't. Well, the Lib Dems issued an email saying, oh, this is an extremely dark and sinister day for politics, and taking it like that kind of angle, you know. And that, you know, we're in dark times. You never entered a dark time when you've got all these... What's dark is that they've actually figured out that, you know, we're in dark times. So I don't think they even know that we're in dark times anyway. And that a lot of this food's unhealthy, and, you know, been making loads of money out of it and implanting all the food outlets all around us everywhere, installing them. And then, you know, we managed to get an oligarch, Donald Trump, to actually move a little bit away from being a full-on oligarch and coming around to see sense that, you know, we need to help people and make them healthy. I mean, it's never a dark day if you can get, you know, the ultra-rich mega oligarchs to come along to see the light, you know, and step a little bit away from being prioritised with money and profits, you know, and actually, you know, a bit more care about people. It's never a dark day. So I don't really know where Ed Davey's coming from. I really don't know where Ed Davey's coming from with that. And what it shows, I think, is a little bit like, I actually do think that, you know, I don't think that they're that liberal. Some of this wokish kind of sector, I know that a lot of them are vouching for charities and, you know, and so forth, but a lot of them are very, very tied in with, you know, the whole celebrity thing. Even the Green Party, you know, get into all that. I'm not saying that, you know, the Green Party and the Lib Dems are anything like X Factor, but they have their fair share of it. You know, so I thought it was a little bit extreme or offensive to say that, you know, we're entering a very, very dark time when a big oligarch guy is just sort of like really going to taking a step or a few steps away from being an oligarch, you know, towards the other direction. How can that ever be a dark day? So I don't know where they got that from. This is just more wokery, though. This is just... They'd love it if we couldn't really complain about anything. This petitions committee policy currently is trying to neutralise anything that is anywhere potent or any real challenge or contest. It's almost kind of like our position now in law and order. We've got a little bit of citizens' arrest that they say we've got, but if you try and go around and do policing, you know, the police are just like, out of the way, peck, you know, they've got the backup, the devices, the walkie-talkies, the equipment, the training, blah, blah, blah. And then even if you speak the law and say you're using it, you know, they're just like, you know, it's... They aren't interested. I tried to use the Public Meeting Act and phone the police up to get a complaint, and she just hung up on me. So there isn't really. It's almost like there's hardly really a proper right to petition by the time you can't really write much on there. It's almost kind of like we were meant to go, report and get arrests for civil matters and criminal. We could get, it didn't have to be the sheriff who went and arrested them. Usually people went and got the sheriff to do it because it was just easier for them and they didn't have to do the rough work, but they could walk in with a complaint. That the whole point of the sheriff office is like, you go in there, you've got the complaint, right? You write the petition, the complaint, and then when you lodge it there, official, it's like, okay, now it's this person or that person. There's a warrant. The complaint has warrant, right? It has to warrant action, and it's got you had your oath and statement on it that's the truth. So it's like, on the cartoons when they go, it's hunting season or all open season or whatever, and so forth. It's like everyone, if the thief cannot be found or apprehended, sometimes the whole village gets fined if they don't find them. So when you put the complaint into the sheriff's office and it's like, okay, there's open warrant out on John Biggs, everyone, if John Biggs is not found, it's not the sheriff's just got to go. If John Biggs is not found and the village don't find John Biggs, the village have to pay a fine, So they're all on open warrant, they can use reasonable force. They can all, but anyone can use reasonable force now to defend themselves. But it's, you can pursue the guy and apprehend him and bring him in. But this is the thing. This is meant to be what we're doing with the petitioning, right? You've written the oath of the petition and signed. You've written the complaint out. You've submitted it to Parliament Petitions Committee, and when they publish it and they say, right, now it's open, you can sign it. It's like it's on license, it's on warrant, and this is the thing. If you pursue it, acting to compass that warrant, acting to pursue it is under privileges. Now, what does that entail? Well, the main primary direction is to share it, right, and deliver it to other people and to get signatures. So, walking around with a pen or like walking around with a pen, collecting signatures, advertising the cause, whatever the cause is, to raise awareness of it, what have we got to now? All right, yeah. So, yeah, I mean, you're actually on warrant. You're on warrant to pursue that petition, and really, it really should be a lot more than that, because you really have a right to get the evidence for it, to obtain the evidence, or you can't show off anything. And they're asking you for that. They're saying, any evidence that you use or say has got to be, proved or real or whatever. Well, how do you prove it unless you obtain facts and truth in order for you to put a true statement down on there? These are the arguments that we've got about, and it cannot be any. What Parliament and petitioning is it's doing exactly what you're doing with the civil or criminal matter, but under Parliament's jurisdiction, which is all of the country and above those courts. And they're not meant to intervene. And you're meant to have freedom from arrest, because it's meant to be important if you're doing it for the whole country, and freedom from arrest and imprisonment, which is what the right to petition is. That is what the new constitution is, the Bill of Rights, and freedom of speech in and out of Parliament. And actually, you haven't got freedom of speech on this petition with all these rules, right? Even if in Parliament you swear at the Speaker, you've got the freedom to do it, right? And he might send you out, right, or whatever, but you had the freedom to do it. and you're meant to have freedom from arrest or imprisonment. Although I think there's meant to be a naughty prison for MPs that the Speaker will put you in at one point, I think, and the Sergeant at Arms. But generally, that's if you actually, pick up, try and, rip the chairs apart or don't behave in that manner. I'm talking about just merely voice and words, because they shout and do strange behaviour in there anyway for tradition, mainly because of that. But the freedom of speech and the 1688 Bill of Rights in and out of Parliament is meant to be for all political matters and causes, and you can't be arrested or prosecuted. Now, they're only doing all these rules and etiquette out of tradition and ancient custom, right? You can't be prosecuted or arrested for it. Now, really, they can't stop you from doing it, and you got the right of the subject to petition, right? Now, if they don't want to publish it on their website, but the thing is, you've got the right to collect the signatures. Okay? So collecting the petitions from the public is how you petition the king, isn't it? Now, you might say, are you asking for the king's signature only? Is if there's a right of subject to petition the king, are we only allowed to ask him for our signature? No, it's you're presenting, delivering the signatures to him, surely. You hand the petition into him with the signatures on it. You're not asking him for his signature, surely. Well, that's what it suggests in the 1661 Act. Then this one, the next one here is, well, so the previous one we've decided it's just mega woke, and it's starting to try and gradually restrict really any it's trying to bring in those, what it's trying to do, I think that it's trying to, these protected those protected characteristics, right? Race, gender, sex, age. It's trying to protect them from petitioning. It's trying to protect race, gender, sex, and age from being petitioned about, in a way, I think. And that would mean that you don't have the right to petition about those subjects if that was the case. So it's trying to take away your right to petition about certain subjects, and even petition about those subjects, or even question them or whatever, right? And that is illegal, particularly on the free speech as well, the free speech in and out of Parliament. And the thing is that politics is meant to be one of those characteristics, right? Because, sex, age, gender, sexuality, and then really on it's personal views is meant to be one of them, including political views, right? And they're really... So it's kind of like something that's meant to be a characteristic that's a protected characteristic, or at least, like Julian Assange, if he'd have political views, he wouldn't have been able to have been extradited, and they shouldn't have arrested him if it had been political views, right? Those political views are a protected characteristic when it comes to extradition, and they're a protected characteristic under the Copyright Act 1911 under Section 20, and they're a protected characteristic when you're copyrighting things and you get a certificate from the Speaker, right? But when you petition in Parliament, this mega woke committee doesn't seem to think that it is anymore, and they're trying to remove it from there, because then you can't do what you want and you aren't protected, and they're the ones who can tell you what you can and can't do with the rules, and then they can prosecute you. And if it is a protected characteristic, then you can challenge all other characteristics and say, well, no, this is the protected characteristic, not those, right? And what they're trying to do is actually say that you can't petition about these characteristics because you don't have any rights and you're not protected. But what that itself, having rights and being protected, is going to be a protected characteristic. It's like the main thing that facilitates you being able to do anything, they're removing it. And in a way, it's almost like Christianity is the right to petition. They're claiming we're letting all these other religions in and we can't discriminate against them, but at the same time, they're banning praying. it's as bad as banning praying. It's like saying you can't pray outside. Effectively, these rules is the equivalent of petitioning Parliament, as in what they're doing to Christianity, which is let us pray, right? They're saying, well, we're not letting you pray here, we're not letting you pray there. Well, it says let us pray. Well, you can't pray near or outside an abortion clinic, but the religion says let us pray. Well, they say, well, it doesn't say let us pray where, though. Well, you pray when someone's dying, or you're near anyone who's dying, or passing away, or ceasing life, or being born and coming into the world, or getting married, right? Or if it's Christmas, or Michaelmas, or whatever, or Easter. But, bare minimum, coming or going, right? So this is the thing. It's like they're actually... all the time they're saying you can't discriminate against these things, but they're actually cutting right into them themselves and taking them away. And Starmer really takes the biscuit with his, assisted suicide, with his anti-Semitism, right? Because it's very hypocritical what they're doing, which means that they can't really be protecting anything. They're assimilating everything, dismantling everything, and claiming that they're saying bring everything into the room and don't, question what we're bringing into the room while we dismantle it. But, if you say we're dismantling things, that's accusing us of wrongdoing. So don't, it's like, speak to man because we're facing listening. It's like, don't tell us what we're doing or judge us. And we can't be their judges, but they can be ours, right? It's terrible. This is, I don't know how this came about. It's something to do with social media platforms, these big campuses, colleges, elites, TV shows, mainstream TV, Loose Women, Jeremy Vine, MSNBC, Love Island, Simon Cowell. It's something to do with that and the fact we've all got these block and ban buttons and we're just pushing them left, right and centre. But these guys have got big buttons. They're just not on social media. They're the control of the government and these services that we're meant to be able to access that aren't meant to be pleasant or nice. Having to petition the government over very, very serious matters is not a nice thing to have to do. Read the archives, see what type of matters were being raised. It's never happy or sweet. It's always sinister, distressing, and a misfortune. They want it to be like. It's almost like, we're not going to have a pet bunny because they smell and they get wet and damp and wee everywhere. And, we'll just have a soft toy one instead. It's like we can't have a real petitions committee because, there's crime involved or misfortune or poverty, poorness, illness, disease, suffering. People have been mistreated, they want compensating. People have been abused, all kinds of things. Read the archives. What they're trying to say is, can't we just have the plush McDonald's drive-through Hamburglar instead? Hamburglar stole a burger, didn't he? Sometime, but that can't be that bad. It's not bad having a Hamburglar character, a thief, as a hero of children. We can have a soft, squiddly toy Hamburglar, but you can't have any petitions that, are about ongoing legal cases or anything like that. Or even, bring wrongdoing to our attention, But we can have Hamburglar because he's a plush, soft, cuddly, cute, squidgy toy, Contains material that won't be appropriate to publish as a parliamentary petition. Well, that one really is that is the cut-off switch, isn't it? Who decides what that is or what is not that? Contains material that wouldn't be appropriate to publish as a parliamentary petition. That's like saying, we can delete your account for any reason or no reason. Well, actually not, because you can't have, sexist, racist, or whatever, unless you had a protected characteristic such as parliamentary privileges. Parliamentary privileges actually is a protected characteristic of the political sort, it is a protected characteristic, parliamentary privilege. You're protected from being prosecuted for what you do or say about things, protects you from prosecution and arrest. They've done this in a really nasty and cunning way, and these rules have been updated, and I thought they were getting better, not worse, but they've even gone more woke. Now, what Starmer has done is, I said, can we have the legislation on there and all the proper legislation that the petitions committees were meant to run on the history of England? And what they've done instead is Starmer's put out these absolutely flamboyant, preposterous and unacceptable, criminal, illegal rules, which just cannot even be entertained to be truth or fact. And here, he's trying to get people to stop talking about these protected characteristics, right, or all these pronoun wokeness, right, but underneath it contains any material that it wouldn't be appropriate to publish it as a parliamentary petition, right? To publish, but it doesn't mean to say that you haven't got the right to petition the government over it, or that you can't submit a petition over it. Just wouldn't be appropriate to publish it, but appropriate to who? If they say who, then that might help, because if we are in deep trouble, and for example, this petitions committee isn't putting lawful rules up, and we're being obstructed from petitioning about serious things that we need to get signatures on, and they're not allowing us to officially do it on the proper website to make it legit and collect signatures on it, and we aren't getting privileges, and the matter is actually really important, and the country, the future of mankind depends on it, right? Now, for us, it would be appropriate. For example, if the mentioned privileges even exist and that we should be using them, because it's very inconvenient. The inconveniences of parliamentary privilege, which may occur of parliamentary privilege, like, when you're outside protesting, the police jumping on you all the time, right, or people telling you to be quiet or shut up, right? The inconveniences that may arise from privileges of parliament, that is actually an act of law, right? So, it contains material that wouldn't be appropriate to publish as a parliamentary... For who? This is like what Robert F. Kennedy Jr. has been saying about this, like, misinformation and malinformation. They've come up with a new term called malinformation because it's inconvenient to them if people know about it or if it's heard, right? Well, this is the thing. People knowing about parliamentary privileges, it's in the law and the committee operates on it. So why shouldn't people know about it? Why shouldn't people know that you can get a certificate from the Speaker or apply for one, and so forth? But the Petitions Committee might not like it because they might not want to have to grant people those privileges or people to really know about them. They might want to keep them secret, but you've got a right to understand your constitution and use it and apply it to effect, right? Now, it's appropriate for us. It's very appropriate for us. It's very, very, very appropriate for us for that information to be included in the petition and for people to know about it. But it might not be appropriate for the government. Why? Because they don't want to give us privileges or people to learn about them or know about them, right? But that's appropriate for us, but it might not be appropriate for them. So who? It wouldn't be appropriate, but for who? For the Conservative Party, for the Labour Party. It wouldn't be appropriate for whom? If they tell us who it isn't appropriate for, it would help, and then we'll know whom side that they're on, and then we might actually see if there's a bit of a lack of impartiality there, and we might be able to say, are you failing to be impartial there if it's that he's not appropriate for you, because it seems that you might be lacking impartiality to us, and you might be showing some bias towards you over us. If it's not appropriate for you, for the committee, then, well, is the committee lacking impartiality, therefore, and showing bias towards itself? Well, if it's appropriate for us, or inconvenient for us, or for the Labour Party, but then again, it's not meant to be acting in any favour or disfavour of any political party, but if it might be inappropriate for a political party, but indirectly, without intention, if, we might whoop their ass, then this is the thing. So whom is it appropriate or not appropriate for? It's almost just like saying that, we can delete your account for any reason or no reason. We don't have to have a reason. Apparently, who decides and judges this appropriateness? This is the thing. Are they going to give a full report on it or not? Or is it just going to be like Google, when they just give a very general thing, they don't have to tell you really why or what's going on, and they won't even argue it with you. This is very evident. This here is evidence that the policies that Facebook and Google are pushing clearly are coming from this government. And this government are the ones who are telling 77th Brigade to take everything down. This government are telling 77th Brigade to remove people's things when they might be, not appropriate for certain people or whatever. Unlawfully taking them down, by the way. And therefore, I think that whoever's come out with this is really the real people who are behind 77th Brigade and Battalion, and really behind the online platform policies that have been encouraged, which is, for Facebook, it's Mark Zuckerberg and Nick Clegg. And Nick Clegg was a Liberal Democrat with Cameron, and Cameron sold off the Royal Mail to these big corporate entities who were saying accept, submit, consent. And Clegg was in the Labour Party with Ed Davey, who Ed Davey's meant to be this, really, nice guy. And then now Trump's won, he's gone very, very sour and saying that the world's all gone to darkness, when the only thing that's dark is that everyone's woke up and realised, it's all been screwed. It's definitely not a dark day when at least one oligarch has, taken 2 steps towards, meeting the poor people in the middle. That can't be bad for anyone, no matter what you think. But these are not only woke, they're actually illegal. They're trying to make out that, it might be you've perfectly got a right to petition and you can submit it to the government and you can do it, but it wouldn't be appropriate to publish it. But what about in Hansard? If you've got a right to submit it and you've got a right to collect the signatures on paper, and it's got to be a right to heard, if you're collecting, they can't stop you collecting 1 million signatures on paper, which you've got to compel anyone, right? Now, that's going to get put in Hansard, right? And they can't stop you from getting 3 million signatures or 50. And if you get 50, they can't stop you from getting it published, right? Surely. And it's going to go in Hansard and be published anyway. So, and what kicks in is your Parliamentary Papers Act and your certificate. And no one's liable to, no one's liable to any legal consequences. And anyway, the right of the subjects to petition very serious matters about Parliament, about anything, it has to be strong, powerful, and thrust through when needs be. And this is definitely not supporting that. It's very paranoid in a china shop, it's like being paranoid in, it's like kind of like, being in a very claustrophobic room with lots of objects and, being exceptionally careful about knocking anything over when, there's this, the building might be on fire, and that's the last thing you need to be concerned about. There's serious things going on in the country. Effectively they're saying that not only would they not publish it on the website, but they won't be prepared for it to be in Hansard either. So you haven't got the right to petition about things that they don't deem appropriate. That is criminal. That is criminal. That is criminal, because that you no longer have the right to petition the king. This is worse than Charles, you know, and trying to get all that World Health Economic Forum stuff through, and the WHO taking our rights away from the 1700 Act of Settlement, you know, when it says that you can't override our rights. And this is what this is doing. This is actually overriding our rights. The Act of Settlement 1700 says that the government shall not take our rights away from us. And these set of rules is doing that. This set of rules is taking your rights away. Because effectively, it's saying, right, if it contains material that it wouldn't be appropriate to publish, well, that must mean handed as well, not just on the website. As a parliamentary petition, they've got a right to reject it. So they're choosing random things which may not be appropriate. But that's actually not actually defining anything. They're saying it could be, we don't really, only not appropriate. But how can something which is fully protected in law to the extreme that you shall not be arrested for your actions, no matter what your actions, you cannot be arrested for your actions, and you cannot be actually put in prison, right? How could appropriateness possibly entertain intervention or rejection? How could appropriateness, is it appropriate for the police to come into someone's house and kick the door in? Is it appropriate? Is it appropriate? Is it appropriate for the police to take all people's computer equipment from reporters? Is it appropriate for Keir Starmer to lower the fuel allowance? Is it appropriate for 15-minute cities? No, it causes great grief and suffering. This right and law is meant to be sharper than a sword. It's meant to be tougher than boulders. It's meant to be the stuff that men are made out of. It's meant to be the stuff that sea captains are made of, and knights, and men. And now it is whether it's appropriate or not. But yet we've got this police force who they're giving more powers to take your things without a fair trial, only on suspicion, without any real proof or evidence. Enter places. The police are getting more and more strength and powers, more inappropriateness, and we are being reduced to feeble. We can't even speak or say what we want, in case it may offend someone, but the police can charge in and pinch your nipple. Extinction Rebellion were at an event, and the police officer said, if you do not do as I say and comply, I will hurt you. I'm going to apply pain to you, and I'm going to fucking hurt you. I'm going to bite you. I'm going to bite you. I'm going to twist your nipple. I'm going to hurt you. Right? Until you do as I say. Merely because, you know, I have reason to believe that you committed the crime. Right? What is the appropriateness in that? You know? This committee, these cases are higher jurisdiction than the police force, and we don't have to have multiple codified acts of law that we're acting through, because it's not acts of law, it's jurisdiction of court, and it is not in their court jurisdiction. It's not in the jurisdiction of a magistrate's court. It's not in the jurisdiction of a civil court. It's in the jurisdiction of the Parliament of England. You can't be judged in those other courts, right? Even if you do break the law or not. And that's the difference. And we're being reduced to a soft, cuddly toy, which is appropriate or not. Defamatory, libelous, or illegal in another way. Well, what other way? Illegal in another way to what? Illegal is against the law of England. There's no other way to be illegal than breaking the law in England. But what other way? Defamatory, right. These rules do not apply to petitioning. These rules are illegal. The Parliamentary Papers Act of 1840 fully and utterly completely covers and deals with the subject of defamation resulting from the use and publication of parliamentary papers, which would include this website and answered on any public knowledge or reading or information coming to the public, including the actual petition that you addressed to Parliament in connection with Parliament and signatures you obtained on it for that purpose, and so to judgment, right? Defamation is covered, it's discussed, it's covered, it's debated, and is accounted for under privileges of Parliament, right? And because when they know it's going to happen and occur. So these rules are not correct to the laws of petitioning and privilege. They're wrong, and they're also forged because they're trying to make out that they can even have them when they can't even have them, because that takes away your right to petition. You don't have a right to petition any subject anymore, only the ones that they deem appropriate. What other way? Making false or unproven statements. Every statement is unproven. Who even wrote this? Unproven statements. No statement is ever proved, because it's not proved until after the case is over. In fact, the whole objective is to prove it with a jury. It is never proven at the time you write and submit it. False or unproven statements about a case, there are active legal proceedings, or about something that a court has issued an injunction over, an injunction against the Petitions Committee for doing these rules in between sessions of Parliament, about an individual person or organisation that the UK government or Parliament is not responsible for. Well, Assange wasn't supposed to be responsible for, at least that he wasn't supposed to be arrested because he had political views and opinions. Offensive or extreme, confidential, or likely to cause personal distress that includes a petition that could intrude into someone's personal... Oh, I think that's repeated, that one. So, who's deciding what would or wouldn't be appropriate? That's the thing. Most of the, if it isn't something that the government are doing, like Alfred, is buying. It's like Jeff buys cars, isn't it? Jeff buys cars. Jeff's buying cars, right? Make Jeff buys cars illegal, or something on YouTube. That is not a. We agree that it's not a government departmental thing. It's just how these are written. They're just terrible. They're not written like a government of Parliament. They're not written like a government of a Parliament of a country. They're written like there's some social media platform or something. And if Parliament has become a social media platform itself because it's online, it doesn't mean to say that you have to have the rules and regulations of a social media platform, because the government is... we're meant to be making the laws up, and this is the process by which you make the laws up and get them changed and challenge the laws and narratives and challenge what is being done by this government and the things that are happening in this country. And the thing with the platforms is it's very difficult to challenge the platforms because you can't get to them. They're in another country, and they don't speak to you or reply to you like, Clegg, and they've got caps on everything. They're untouchable. The government didn't actually used to be untouchable. I mean, look at Cromwell. The government's not meant to be untouchable. I mean, George Galloway got in there at least and stood up and took his oath and went and said his words, right? Parliament is not meant to be untouchable. You can go there, and you can you even in the 1661 Act, you could have 10 people who could approach the king and hand a petition in. I don't think they can stop you doing that. Obviously they've got to check you to see if you're armed or not. But I would have thought that you can hand it in. They've still got Graham Smith shouting through the megaphone stuff. Anyway, there's no doubt that some people might put some ridiculous things on there, but this kind of goes in the extreme. You wouldn't need to write these rules in order to just reject petitions that weren't about a subject, but they're using these rules and they're using them in the manner to make out that they're protecting certain people who might be vulnerable or whatever, but they're not using them in that manner because instead they're using them to actually block and obstruct true strong politics, true actual political change and the potential for political change, I think. Some of these are actually illegal, some of these clauses, and that's a breach of privilege, which means that they can be prosecuted at any time, not just between sessions. And the Privileges Committee is meant to deal with that, which is actually includes the Attorney General, funnily enough, confirmed in standing orders. It's confirmed in standing orders. And also, another thing, if you've got to collect 5 signatures, which is not easy, and it's pretty much a pain to have to collect those 5 signatures, and they're restricting the amount of words you can put anyway, so I don't think really how they've got it set up at the moment that many people are going to go out of their way, to say that, whatever Matt Hancock's a nonce or whatever, or, bring back Top Gear and, sack Simon Cowell or something, because you got to collect 5 signatures for it, and you can't even really write that much, even if you wanted to slag Cowell off. That to say they're protecting persons is more of an excuse. They're actually trying to stop you. It's not. The lie is that the whole pronouns he, she, him, they, protecting racial protected traits, or not wanting some old lady and her daughter in Penzance to get upset or something. That's not the real reason for these rules. The real reason for these illegal rules is so someone cannot get an extremely potent evidence, statement, petition in great detail and length, like that we've done on petitions.net, and not have to just send it in through the post. Actually have it on there and people read the evidence and actually get a massive amount of signatures on it because people are like, wow, and actually they might learn something about what their rights are, and they really will make an effort to share it, and you end up getting 30 million signatures. That's the real reason, and it could potentially end up with both political parties getting sacked and fully independent members in Parliament. That's what they're trying to stop happen, which is it's political party control, it's control of Parliament, it's a Labour jury, and we know what happens to Labour juries. No one wants a Labour jury because Labour juries don't pass planning permissions for factory owners if they don't lift their pay rise up. And that's why we don't have Labour juries. And Labour juries don't let people petition Parliament to remove Labour juries. Labour juries don't let people give evidence in a court. Labour juries ban people from bringing evidence into a court that could, remove Labour juries. This is the thing. Interestingly, there are lots of rules that juries have got to follow. Like, if they break the rules, apparently they can get removed. That's the position that this petitions committee are in at the moment. I think, and it's a brand new committee. It's only just been formed, and they've already got all these. They've already got all these rules up. And there was a rule that said that you could appeal if they rejected a petition. You could appeal it properly, and they've removed that information now. And I have to go try find what disk drive I've got it on. So it's many of these are actually illegal and also impossible. Just can't be possible because of some existing standing orders that are clearly obviously there. Because of legislation and the definition of advertisements, the existence of the Monster Moving Loony Party, loads of things. I really would like to take civil legal action. I'm starting to think that I think you can take civil legal action against them in between sessions of Parliament, but that might be too late. But the fact is that I think it's a breach of privilege and a matter for the Privileges Committee anyway. I actually think it's illegal. And the Attorney General's in there, it's contempt. It's actually contempt of Parliament, not contempt of court. This is meant to lead to impeachments. Things like this are meant to get people impeached, and that's pretty much it. And I think that when I edit all this video together into one, because it's in separate parts, it's going to be about 3 hours. And I don't think the Attorney General or the Privileges Committee wants to have to sit and listen to it for that long, but these are all of those points and examples, even though if they might be a bit long and extensive, are correct.